there is no relief against me. I'm not even mentioned remotely. Then, my lord, the pleadings are completed by both parties. Both parties submit their issues, the draft issues. No issue is raised. My lord, after both parties submitted their draft issues, the matter was fixed before the Honorable Tribunal for framing of issues. At that stage, this application was moved to implead me, who is not a party. Now, my lord, the other very important aspect which the division bench has lost sight of is this. Admittedly, my lord, Cox and King says the intention of the parties has to be inferred based on the cumulative factors. Now, the dissent opinion of one of the arbitrator is that there was an intention of the parties from the very inception. Para 6 of the dissent order, my lord, notices this fact, that the first agreement, second agreement, both notices that I reserve the right to assign my all rights and liabilities to a third party, whereas no such right was conferred on the claimants. And my lord, finally, in the second supplementary agreement, para 3, specifically says all my rights and liabilities have been transferred. And my lord, in fact, the three claimants gave the same right in favor of Gokulam, that Gokulam will represent their rights. Now, my lord, the intention of the parties from the very inception was that I will have the right to assign, which finally I assigned. And they had...
The assignment was not a complete break from the prior framework agreements.
Lord, if I
Those agreements do not expressly stand terminated by the, or they, it's not a case of novation.
Lord, if I can invite, Lord, may kindly see page.
Goodwill was being used. Your goodwill was being used because by clause 23, the advertising and everything about the project was under Mantri's name.
Correct, that's right.
So if that is so, there was a commonality of interest in the contractual obligations. We are not going with regard to the holding or the character of the signatory and non-signatory. But more importantly and fundamentally, the structure of the agreement was not a clean break from the earlier agreements into a novated domain.
If I can read just 3 lines from the second supplementary agreement, annexure P1 at page 89, it says, whereas MD, that is Mantri developer, has now nominated LM, which is now the respondent. This is Castle Vista, to take on the rights, duties, obligations, and liabilities of MDPL under the agreement and the first supplementary agreement to which the landowners hereby consent. So this is a complete handover. And then, Lord, may kindly see I for a second. Whereas the landowners have deemed it fit that the project of this scale must be handled by a company having primary business of real estate and property development, have identified GSPL as an agency fit for that purpose, whereas GSPL has represented that it has established. Now, my lord, the landowners nominate GSPL, I nominate Castle Vista, both, and now it was the Castle Vista and GSPL. They were supposed to undertake it. Now, my lord, the dissent opinion, if I can invite my lord kind attention.
Since you are on the clauses, read 4.5.
Yes.
Read 4.5
and 4.6.
It's not a novation. It's set out in the paragraph 31.9 of the approved order.
Page 30.
Lord, this is up to 4.8.
Says second supplementary.
Yes, that's right. That's right.
Let the earlier agreements and they constitute an entire agreement, an understanding amongst the parties with respect to the supplement. After this, nothing remains.
Lord, in fact, whatever rights and liabilities I had under the framework agreement.
Then another agreement, the third, fourth, and they must be only for to dupe either financial institutions or the home buyer.
No, Lord, I am the guarantor.
Fraud, this kind of thing.
No case to interpret of this.
And Lord, for that financial institution, suit is already pending against me. And this very claimant filed a suit against me. And this fact was not even
cheating. This kind of agreement. These are all element of cheating. Because somebody is the home bias or the financial institution.
Please. Great.
Yes, 57.
माय लॉर्डशिप, मैं भारत में जो जातिगत जनगणना हो रही है, कास्ट सेंसस, उसको
आपको ये कहाँ से, ये भाषा कहाँ से सीखते हैं जो लिखते हैं आप इस पिटीशन?
सर
पिछली बार यहाँ पे शराफत से भेज दिया वापस आपको?
नहीं सर,
ये बदतमीजी की लैंग्वेज कहाँ से लेके आते हो लिखने के लिए? किसने लिखा है आपके पिटीशन?
My lords, petitioner is facing litigation since last 20 years.
अब क्या करें आपसे हाई कोर्ट?
Only request, my lords, kindly
How many matters you want the Supreme Court to direct?
any direction, my lords, within reasonable time, my lords. Within reasonable time.
Limited time is all right, but how many matters we will keep on directing? With 2023 writ petition, which are the oldest one in that act?
My lord, they are facing litigation since last 20 years.
Facing or facing no case to entertain made out dismissed.
My lords.
नहीं, कोई order नहीं कर सकते आपका. We are asking for grant in aid. People are waiting there for who are in jail. People are waiting for senior citizens.
Kindly dispose of, my lord. Kindly dispose of.
File this kind of thing.
Kindly dispose of, my lords. Dispose of, my lords.
No case to entertain writ petition made out dismissed. Unless you want to withdraw.
Withdraw, my lords. Kindly withdraw.
All right, withdraw. एक ये क्लोज बाकी है. Withdraw वाला कर देते हैं.
Report says
Pass it on.
तुम सीनियर कौंसिल में आते
Yes.
हैं. The cost rate will increase
Lords, there is a rampant illegal mining, my lords.
because cost is proportionate to the capacity to pay fee.
No, lords.
Because if a leading senior counsel is engaged, we have also, if we may not be knowing accurate fee structure,
I'll
but
argue.
we have an estimated idea.
No, my lords. I haven't engaged any senior.
Even if we impose 25% of cost, good enough for us.
There are photographs come, my lords, so I need to file it, my lords. Otherwise, there is a illegal rampant mining is happening in the government Porambok land, my lords, which is adjacent to the forest land, my lords, in Ariyalur district.
If Justice of the High Court has obtained report,
Yes.
after the report is satisfied that there is no illegal mining, whatever mining is taking place is only after obtaining all clearances. The land where you are saying that illegal mining is not found here.
I have-
Or after somebody, who is financing this PIL?
No, my lords,
Somebody.
it's a local organization, my lords. They are the villagers, they belong to the local community, my lords. And they see there is a illegal mining, my lords. I have the photographs, my lords.
Photograph mining is there, they are not disputing. They are saying mining is.
It's more than 15 meters they have been digging, my lords. So they have been allowed only to dig 2 meters, my lords. That's the lease condition. And it's very close to the forest area.
Should have controverted the report, you should have filed something.
correctness of the report.
Yes, my lords.
Just by saying report is wrong will not do, sir. Where is the affidavit or any document where you controvert the findings of the report, which is page 42, 43 of the SLST? Report clearly says that SF number 16 and 13 adjacent, there is no mining, and the other SF numbers are not adjacent to the forest. And wherever the mining is up to 2 meters,
You should have filed a comprehensive rejoinder before the act. Maybe that whatever material was there, still you can represent the authority. Closing of this PIL proceeding does not mean that
Yes.
something wrong is happening. Then bring to the notice.
I may be allowed to represent before the High Court, before the authorities meet.
No case to being closed. Although the High Court, 25th November 2025 is made out. Comma, we still grant liberty to the petitioners to approach the state government along with the material planning to show that the mining that the excavation activities are being carried in the forest.
Deeply acknowledged.
Your Lordship, a letter has been circulated in this matter yesterday.
All right, you are granted. 61.
My lord, there is already an existing order. Matters has been directed to Delhi High Court, my lord.
Not dismissed, probably we had said something.
There is a 25th March 2026 order.
Same order.
Same order. There is some error in that, my lord. Typo error is there. It's a 2R, the regulation, schedule regulation 2R. This is at the 46th page, my lord. Kindly have a look. I'll be grateful, my lord, if it is corrected. Section 2R, my lord. It is section 2Q here. And there is a typo error here, my lord.
Section 2R.
R.
ये R कर देना उधर में पैरा 2 में और suo motu इसके ऊपर देना suo motu we taken on report and correction is there.
Grateful, much.
Milords, we have filed this MA in SLP number 693 of 2023 for the restoration of the SLP number 693 of 2023. The reason behind this is that, Your Lordship, on 4th...
You were only performer respondents, right?
Yes, Milords.
The other persons have entered into settlement matter has been disposed of, well withdrawn.
Please, dear Milords.
What stops you? File your own SLP. You became master of your own case.
Milords, filing the whole new case...
Instead of depending on the shoulders of some other person, you file your own SLP.
Milords, we would be filing the whole SLP anew.
You have to, because that is the only procedure. Otherwise, at the instance of performer respondent, we revive the procedure.
Milords, but there was this transposition that was filed in the same SLP, which was pending before the withdrawals. Deeply applied, Your Lordship.
Please, Milords, the writ petition of the petitioner, Milords, is keep listing for final hearing, Milords, before the Honorable High Court of Chhattisgarh, Milords.
2025 writ petition.
No, Milords. Initially, it was filed on, Milords, 2020 as a writ petition service, Milords.
The present petition, sir, you are asking for is 2025.
No, lately it was converted, classified as not Honorable High Court as.
You don't have time and your status does not permit you to approach the High Court for early hearing. You come straight direct to Supreme Court.
Milords, all the pleadings have been completed, Milords. The matter is only, Milords, the limited prayer is, Milords, the matter may be heard finally and decide on its own merit, Milords.
No case to entertain the petition.
Milords, please consider, Milords, because it is pending since 2020, Milords. Milords, is pending since 2020, Milords. Please consider, Milords. Milords, any direction may be given to the High Court, Milords.
Sorry, we will not.
Please, Milords, please consider. Because it's pending since 2020, Milords.
We will not issue any direction as you are asking. Sorry.
I'm good, Milords.
Item 64.
Application for withdrawal.
Sorry.
There's an application for withdrawal.
As per this.
Much obliged.
Console.
Please, my lord. Milos, we have, after that landmark judgment, Milos, only one clarification I needed. Milos, the tribunal, if my lord will see page 67, the tribunal gave us two directions that they will consider for pension. That right has been taken away. Lordship may-
Review.
No, Milos, I'm not wanting review.
It's not a review, Milord, a very simple thing.
Milos, may kindly have the tribunal's order which says, page 79, Milos, only one thing. We are only saying, Lordship will say, we don't want that to be disturbed. That's okay.
Our benefit has been granted by tribunal.
Milos, may
No,
clarify because
that is to be clarified. Page 213, my lord will see the direction issued by the tribunal.
it's there.
Page 213.
No, it's not 213, page 79 also.
I think that is not.
In addition to
That
these,
can't actually-
respondents are directed to examine
No,
the feasibility
we
of granting pro rata pension.
We have dismissed their SLP.
Yes, Lordship, that is what.
That means that whatever NGT, AFT has granted to them,
That's all.
if at all, that order remains intact. So we can only clarify one line that
That's-
we have not set aside that part of the AFT order.
My lord,
That's-
that will
is all we
that will
wanted.
do.
Lordship, I have only one humble submission.
And
to be
A
made.
for ka
In para 44 of
A
the
for
Honorable
page
Supreme
81
Court's
for the
judgment, Lordship has already categorically decided about the constitutional inequality. Then about the legitimate expectations.
No, we are not
58
doing that.
onwards, Lordship. Everything in threadbare
Take
discussed.
the mic, yes.
Lordship, in para 44 of the Honorable Supreme Court judgment, Lordship have already considered the issue about the constitutional inequality pertaining to the women officers. Then Lordship, para 58 onwards, about the legitimate expectations aspect, Lordship has already decided. As far as pension is concerned, Lordship, after analyzing the judgment of Honorable AFT, Lordship has come to the conclusion that there is no case made out and Lordship has dismissed their appeal. As
No,
They did not challenge, my lord, the direction of the tribunal.
My lord, may I have page 213? 213 in my lord's judgment, I will show there is not even a whisper of page 213 is the direction of the tribunal, my lords, at para 146 and 147.
No, what was the direction you are asking?
My lords, page 213 first.
213, my lord, para 147.
213.
213.
That's the tribunal's directions. At para 146 and 147. And then,
So the only word is that they are at liberty to press for pension by following other remedies available under the statute. So they may approach you. You can
146, 147, that's all.
Led by the learned judge, if your lordship may considering keeping this matter on next week, your lordship.
We are not passing any order. We are only, and that's the legal position also. No? We have only dismissed the SLP.
Yes.
That means that whatever tribunal order had been passed, that order is kept intact. So in terms of that, they will be at liberty to approach you, whatever they want.
Lordship, precisely that is my humble submission, as well as in addition to the directions of learned AFT in para 147 about the pro rata pension. In our note, Lordship, which we have filed, we have clarified that aspect. Pro rata pension is not automatic, Lordship.
No, we are not saying.
Very right. You will reject it.
Rejected.
Obliged.
Better ends.
They have rejected, they have released, my lord. Pursuant to the order passed by this honorable court, they have released. So, my lord, at least we should not be disturbed.
So once for the party, it is clarified that with the dismissal of the civil appeal filed by the applicant appellants, the order of the AFC, dated 4th September 2024, has been upheld. Consequently, if they are entitled to approach, consequently, they shall be at liberty to approach a competent authority and or seek relief as per para 146 and 147
My lords,
of this article.
my lords, we are very highly obliged. That's
In accordance with
My lord, they have released pursuant to the order passed by my lords. They have released, we are on roads now, my lord. That's
after 14 and a half years, but anyway, Milos. And Milos, there was one very small thing, Milos, in the written submission, something came which shows that I meet the benchmark. I'm not asking my lords to clarify. Written submissions are not supplied to us.
No, now-
On it.
now-
But we can at least go, my lords.
First, our limitation that we are not sitting in the same composition. Number two, that whatever we have done now wrongly, right?
No, we are not there, my lord. But they have disturbed, my lord, and they have released us, my lord, pursuant to the order. So unless, my lord, they decide this in the, my lord, light of the order of tribunal, we should not be disturbed, my lord, at least.
Very difficult to pass.
My lords.
Thank you.
Because we are very obliged even for this clarification, which was the.
Obliged.
So who has? When you keep the same correct, then why? No, that council is at section 2R, not 2Q.
Whichever side.
Yes, 85.
But I think this is the matter where your lordships had passed that order. I believe my learned amicus has filed something. We've not been served, Malaj. We don't know what is. No, this is that Supertech matter where I believe the learned amicus has filed something. We have.
Be allowed to, we will not permit him to work even for a day.
Malaj, I believe a writ petition has been filed on behalf of the IRP.
Even if he succeeds, but the benefit of doubt should go to the home buyers and to the institution.
No, I think, Malaj, I mean, let the ACC take a call on what should be done. Or, Malaj, if your lordships would like, I mean, we can file a reply.
Appoint some high-powered committee then.
No, the ACC, Malaj, comprises not just of the IRP.
Led by the IRP.
The IRP is the chair. But Malaj, honestly, I don't even know what my learned friend has filed.
Head being rotten, how do you?
No, I don't think it's rotten, Malaj.
Irrespective of the.
Let's keep that.
Then prima facie steps have been taken, rightly, wrongly.
That's right. Malaj, the only thing is, I don't know what my learned friend has filed. I have
The
not.
point is that today, the provision permits two types of penal action. One is that suspension contemplating an inquiry, as it happens in service jurisprudence every day.
That's right.
The other is that under this statute, the scheme of the regulation statute, that you are suspended as a measure of punishment. This is a second case.
Malaj, can I just make one?
Second case where after an inquiry, this IRP has been found guilty of any XYZ. We are not concerned whether it is procedural, substantive, touching his integrity or not. But question is that if the competent authority has suspended him as a punitive measure, why should we allow him to continue on this project?
Yes. Fair enough. Malaj, can I just respond to that very briefly? Malaj, may I just respond to that very briefly?
How many total companies are there, Mr. Jain?
The subsidiary companies,
Projects.
16 projects on which the NBCC had undertaken, but otherwise the company has over 30 projects.
So every project will have to be.
Malaj, can I just briefly respond to a few points, Malaj? Malaj, one, the same IRP has steered the process not just before your lordship's court in the past, but also before the NCLAT for the last 3 years. No one has found any fault with the manner by which the IRP has conducted the affairs.
I'm not saying that
in
he has
order
done anything wrong here.
Correct.
We are only pointing out that he has done some wrong somewhere, on the basis of which the competent authority has now taken a punitive action.
Which is
That having been taken, why should we allow him to continue here?
Malaj, so therefore just hear me out for a minute and I won't really. One, I don't know, Malaj, what my learned friend has filed, so I don't even know what is against me and what is sought from your lordship's court. Surely, Malaj.
You can share with them, if you don't want to give the full report, you can just.
Let us at least get some part of
Lordship, I'll do that.
We can, at least we can respond to that. Malaj, therefore, all I'm saying is, Malaj,
This application has been moved by Rajiv Jain and Sri Amrita Kumar. Sri Rajiv Jain learned the Microsoft and his assistant counsel, Mr. Amrita Kumar, seeking permission to place on record the report from recommendations. It may be mentioned that this court had wide noted it 5th February 2026. entrusted the completion of 16 real estate projects to NBCC. The Apex Court Committee as well as the project-wise committees were also constituted. However, on 30th March 2026, the Insolvency and Bankruptcy Board of India, in bracket IBBI, issued a disciplinary order suspending the registration of the insolvency professional, in bracket IRP, Mr. Hitesh Goyal, for a period of 2 years. That order shall come into force with effect on 29th April 2026. It is pointed out that the order of suspension has been issued after IBBI found the resolution professional guilty of some misconduct like statutory contraventions, including failure to disclose material information in the information memorandum, etc. So, next one. Although it is pointed out by Mr. Diwan and Sinha Council that IRP has challenged the order of suspension before Delhi High Court. It seems to us that since the projects are to be completed under the supervision, under the court monitored proceedings, action, it may not be the propriety demand that the IRP, till he is fully exonerated by the court or any other prescribed authority, to stay away from the ongoing proceedings. We therefore find merit in the recommendations made by the learned Micros that a court monitoring mechanism need to be adopted to ensure that the project completion by NBCC proceeds without any hindrance. Next paragraph. We may hasten to add that the company, that the real estate company under question adds some other projects as well. About how many other?
So there are 16 projects which NBCC has undertaken, but total about 30 projects.
That there are about 30 projects undertaken by the company in question, out of which 16 have been entrusted to NBCC for completion. The issues relating to the remaining projects are also required to be regulated. So, are required to be administered through the same mechanism, namely a court monitored mechanism, with a view to suggest a mechanism. Also, in this manner, all the projects completed, partially completed, substantially completed, partially completed, or which are lying incomplete and have been handed over to NBCC, shall be controlled and administered by through only one authority that may be set up by this court. So, with a view to enable the parties to suggest some names in this regard. We post this matter for further consideration on so and so date. Meanwhile, we don't want them, this IRP or who is the authority who will take any decision? No major policy.
No, it's the sorry. It's the ACC, which was the court.
Meanwhile, we direct the ACC not to take any major policy decision.
No difficult. Lutz, can I only make one? Lutz, may I at least get an opportunity of responding to what my learned friend's application may be against?
It's like that the proceeding being passed to maintain institutional transparency, and it shall have no, it shall not be taken as an aspersion on the conduct of Mr. Teshwal by this court. In other words, his pending proceedings shall have that. In other words, this order shall have no bearing at all in the proceedings pending at his instance, challenging the order of suspension. Order of suspension.
Your Lordships, by the impugned order, my lords, by which your Lordships on 5th February had upheld the order of NCLAT, my lords. That order, your Lordships have already set up a mechanism wherein your Lordships have permitted NCLAT and NCLT.
How can that mechanism be effective like this when the head itself is now in
What
this?
your Lordships now have done, my lords, your Lordships, by bringing in the entire company.
That day we, speaking from actual point, I think I couldn't discuss with my brothers in detail because this suggestion came from this side. Look at the members also. Those who are directly, they have their own interest. There is a lot of conflict of interest involved. We need a neutral person. Ultimate sufferer will be the home buyer and maybe the financial institution also. But we are not concerned about financial institutions. We are concerned about the home buyers.
Absolutely.
Those who are already occupied, those who are in the process of suppose occupying.
Now what will happen, my lords, because what your Lordships have just now said, my lords, because the entire controversy before your Lordship was determined was with respect to 16 projects. The Apex Committee with respect to that 16 project. With respect to other
16 projects, you are right. Ordinarily, we would have agreed to that. 16 projects, there is a robust mechanism. You appoint them, they take it to a logical conclusion, and MBBC is completing timeline, people will occupy. The other poor fellows, suppose they have 90% complete, 95% complete, 70% complete, 80%, there is a hue and cry. There should be a holistic approach about one.
I'll just tell you, your Lordships.
What had happened before the National Company Law Appellate Tribunal, 16 projects were only identified. And the terms of reference by NBCC saying this will be the gain, this will be the revenue source, and this is how we'll complete 16 projects. So what I have from NCLAT till this court has been determined only 16 projects. All I am saying is that what is presently required is the reconstitution of the Apex Committee. But please don't enlarge.
You may be right that 16. You may be right in saying that 16 projects require prioritization. For that, of course, we will take, but why the others also be left here?
Other, now including other projects, which was never.
How soon can you suggest some good names?
With respect
to I'll just tell your Lordships one aspect, Malod. The irony is, Malod, and I fully see, Malod, that there is an IBBI order. So 3.5 years, this IRP worked tirelessly to get this company to the state.
Don't invite any order. Today we have.
I'm not inviting an order. The only, if your Lordships looks at the IBBI order, he didn't upload some material on the internet. In fact, I don't even know how this.
Between the individual interest of this gentleman versus the interest of thousands of home buyers, we will have a preference. We will give due weightage to their interest.
That's absolutely right. In fact, that was the whole way in which for 2.5 years the IRP worked tirelessly to get
more time.
So, the irony is after putting the company in a position where the home buyers' interest.
Order, your Lordships may kindly hear the parties, my lords. Before enlarging now the scope of the order, my lord, because what the MICAS has filed, we are not privy.
We list in any case also, yes.
So, but before enlarging the scope of the order beyond 16, my lords, may at least give us an opportunity to make our submissions.
That's why we are giving you opportunity.
My lords, we need to see what the MICAS has filed, my lords. Today,
no, you can request your MICAS. You can request your MICAS. We have already.
Lordships may have it on Monday, my lords.
We have already requested Mr. Jain to share the contents of his recommendation. But this order will be passed. The choice is only to tell the names. Then we will consider. Of course, we will pass ourselves.
Scope, my lords, may kindly hear us, my lord. Because till now, the controversy before your lordships, what have been discussed is 16
What
projects.
will happen to the remaining projects? So tomorrow they will come.
Projects, my lords, will
And
present
these
data,
people,
my lords,
they-
nothing in the remaining projects, my lords.
Please don't compel us again to comment upon this, the previous management.
No, my lords,
If we will allow the other projects unattended, they will create, God knows whose interest will be created and how they will jeopardize the allottees or the banks.
All I am praying with your lordships with folded hands, my lords. Today, your lordships are passing an order which affects me.
This
All
person,
please hear
the person who has been in the helm of affairs, they need to be thrown out completely out of this project.
whatever you
This entity
will
must
go down to
remain.
it, my lords. Each and every your lordships order we have complied with, my lords. But before passing, enlarging the scope, your lordships may have this issue on Monday.
We will-
We'll address some.
Monday, you argue, no problem, Monday.
Before your lordships may not say the scope is enlarged beyond it, my lords. Still Monday, we will make our submission, and then whatever your lordships we have to put.
You convince us, we will recall it.
So grateful, my lord. In the meantime, copy I will take from the IR.
You ask us again, we will share with you the recommendation. Item 86.
Deeply lordship.
Lordships are having some Monday.
Up on Monday.
My lord, I appear in 86.
What is the current status, Mr. Ariyar?
Please, my lord.
What is the current status?
The current status, my lord, the FIR had been registered, the postmortem, but an arrest has been effected. Now the difficulty is, my lord, they are shielding the hospitals. The child was at that point of time alive. 2 hospitals refused admission to the child. This is a matter of grave concern. After directions having been given by this court,
Take notice immediately, we want to take it.
and then, my lord, I have something else very grave to point out. The FIR gets registered one day after the incident. On 16th of March itself, the postmortem was available with the police of the child. The postmortem, when lordship looks into it, I have annexed it along with my petition.
Yes, shows that
It is showing injuries at the private parts. There seems to be a blunt object which has been inserted in the private parts, which could be even the person's reproductive organ. No inquiry has been directed towards that, even by the postmortem doctor. He does not opine anything in relation to it. And they consider to investigate the offense as if the offense is only relating to a case of murder. If your lordship sees the FIR, and in the FIR they also proclaim that at the time when the report came to them, the child was dead, which is contrary to what had happened, because this FIR is not giving a true reflection of the facts which were there at the time when they went to investigate. In fact, my lord, there is a video recording which has been done by the villagers out there, where the child was alive. The man has picked up the child and he has rushed to the hospital. That video recording is also available, which they are refusing to accept. What they have done instead is, all those neighbors, they have given them notices under 130 saying this, that you are breaching peace. This is the manner in which the whole thing is being done. There is some hush-hush going on. Especially a 4-year-old child, if your lordship sees the concerned video recording, which is there with me, your lordship can just have a look. My conscience got revolted the moment I saw it. Can you just show it, place it across to the bench?
Write down.
Your lordship will see that the child was alive.
Better we don't see anything. We will.
It's ghastly, my lord, to say the least. And that is not being taken into investigations.
This definition. There's nothing but a second. Talking story
This is in Uttar Pradesh.
of a people attack on a 4-year-old girl child by her own neighbor.
Nandgaon.
The most shocking part of the police offense is that the 2 also exhibits complete indifferent, inhuman, and insensitive approach of two private hospitals, alleged private hospitals,
As the part of
as well as the local police. It is stated that on 16th March 2026, when the petitioner, whom is father of the victim child, returned home from work, his neighbor, in bracket the accused, reached home and took the petitioner's 4-year-old daughter, in bracket victim, with him on the pretext of buying her a chocolate. When they did not return home on time, the petitioner, whom is elder son, and another neighbor went to search for the daughter. They reached the field behind from the Chesram school and saw the accused emerging from the fields. He told them that the victim was still in the fields. What the petitioner found was that the victim child was lying unconscious from a covered in blood.
Monday,
The
Friday,
petitioner took her to a private hospital in bracket list number 3, but the doctor refused to treat. He thereafter took her to another private hospital in bracket list number 4, where too the victim child was denied admission. Finally, the victim child was taken to MNG District Hospital, Ghaziabad. This is government hospital.
Please, madam. That's a government hospital.
In bracket government hospital, where she was declared dead on arrival. Next paragraph. The petitioner and his family members' trauma was further compounded when they reported the matter to the local police station. But instead of taking cognizance of such an horrible offense, the petitioner and his family members were allegedly locked up and physically assaulted. Even the petitioner's wife was not spared. They were asked to remain silent about the incident. On the next paragraph. FIR number 129/2026 was then lodged on the next day, that is 17th March 2026, at police station Nandagram, Ghaziabad, under section 103 bracket 1 and 238 in bracket small a of BNS. That is equivalent to section 302 and 201 of IPC. Most shockingly, no offense under section under the POCSO Act was registered.
Or 376, my lord. Even 376 is made out. Even rape is made out. 375 clause B is clearly attracted.
Nor the offense corresponding to section 376 IPC was added, despite the fact that it was an apparent case of sexual assault. Next program, it further seems that having realized the gravity and seriousness of the offence, the accused was apprehended on 18th March 2026. The petitioner and his family, in the process, have lost faith in the local police as well as the two private hospitals. That's why. We have also seen the Panchanama dated 17th March 2026. This does not record whether the victim child was wearing any clothes on the lower part of her body. But it does record that her private parts were injured and bleeding. The postmortem report reveals that there were several wounds and blood on the private parts, along with various injuries on the head and other parts of the body were caused. The doctor who conducted postmortem also unfortunately failed to record the brutal sexual assault on the child, aggravated sexual assault on the child. Next program. As the facts, the facts and circumstances of this case fix the conscience of this court. We are satisfied that the court monitored time-bound investigation by SIT or some central agency is immediately required. That's why issue notice examinable on so-and-so date. They have in Ghaziabad Commissioner of Police or Secretary?
It is in Ghaziabad, my lord. It is PS Nandgram which is investigating.
No, they have. We would like to ask some senior officer.
Your lordship, we would prefer that it doesn't be investigated by the local police there because they are already threatening them.
That's for the purpose of summoning. We want to know that SSP is there or Commissioner of Police is there in Ghaziabad.
There is an SSP, commissioner. I am told there is a commissioner there.
Commissioner of Police.
Along with IO.
The commissioner and the IO can be summoned, my lord. They can there.
The commissioner is there.
Uttar Pradesh, through its Home Secretary, the Standing Council for the State of Uttar Pradesh is served, who in turn directed to file a status report. The Commissioner of Police Ghaziabad is directed to remain present in court along with all original reports. The SHO Police Station Nandgram shall also remain present. The police authorities are meanwhile further directed to effect service of notice on private hospitals as per number 3 and 4. There is no need to issue notice to respond with 5 and 6 at this stage. 2, 6 at this stage, 5 in local authority. 2, 6 at this stage. This is also for Monday.
Yeah.
For Monday.
There is one small request, my lord. Because she happens to be a victim of both aggravated assault, as far as POXO is concerned, sexual assault, and 376. Her name should not feature either in the postmortem or in the FIR, which they have already featured.
Police authorities and the hospital are directed to ensure that the identity of the victim child is not disclosed. To the extent possible, the identity of her family members. And to the extent possible, the identity of the family be also. And from the document, you may read that. Read that. That further directed not to take any coercive action against the petitioner, his family members or the witnesses.
So grateful, my lord. But they are feeling very harassed there.
Particularly, family members who are their neighbors or what is it, exactly?
The father is a daily wager, my lord. He is finding it difficult because every time he moves out, they summon him to the police station, they harass him, saying that withdraw the case. A poor laborer, how will he withstand?
Them on the coming week only.
Please, my lord.
We want to serve them at the earliest.
Very well.
All the situation, transitional issues will take care.
Very well. I had to bring it to your lordship's notice. I brought it to your lordship's notice.
But they should also remain there, no? Because
At the moment, he has shifted residence from there, my lord. But though he is available, he will be here. In fact, he was on his way to the court.
Lord, I ask for the state, Lord, in this copy, although is to be yet to be supplied to us, Lord, but Lord, as regard the state of the case in concern, Lord, the charge sheet has been filed.
Charge sheet.
The FOXO Act, SC and also.
that is, you are expertise. You have an expertise in this kind of things. You do whatever hanky-panky you want to do, and then you file a charge sheet with it.
How a person in custody was carrying a gun, sir? The accused, according to you, in custody, made a disclosure statement, and when you took him to the field to recover a so-called handkerchief, he brings out a gun and fires at your police, and you fire back.
To that aspect, because the copy is yet to be issued.
Please look into it at page 55. At page 55 of this.
Yes, I have annexed that also, my lord.
It is a very, very interesting report of the police as to how the accused suffered gunshot injuries while in your custody.
So as regards the petition is concerned, Lord, petition is yet to be served upon us, Lord.
Yes, yes.
You take the petition, we have served it. We can't file it without it's being served.
By your comment,
Give
you were apprised by your clients, that is the police, as to the developments of investigation. If not, please get advised.
Accept notice on behalf of the state, Commissioner of Police and SHO, SHO PS Nandagram and Executive Magistrate Ghaziabad. Then you make sure that all of them are present here on Monday. That shows the original report. No question. Ghaziabad is here only. Call them here.
I'm so grateful, my lord.
Please, your lordship, I'm playing for a Passover. Learned Senior is on his legs. Learned Senior Punitjan is on his legs. I'm playing for a Passover, my lords.
Could it be Monday, my lord? Monday, my lord, if your lordship could call it on.
Sir.
That's it.
Lord, Passover would be some difficulty. Monday,
My lords, may grant a Passover, not. My lords, may
Either you argue it or no Passover.
please, my lords. Monday it is. Monday, my lords.
Please argue.
My lords may give a date.
either leave or
7% similar as.
Lordships. Pete.
Let the election be held.
Lordships.
Who is to argue?
Learned Counsel Puneet Jain, Senior Counsel Puneet Jain.
Call him.
Lordships may grant me 5
tomorrow is the date of nominations. As my lords have rightly
The
said.
Lordship's orders covers this. Your Lordship's own order covers.
Call him immediately.
Yes, my lords.
Don't waste time.
Yes, my lord.
Continuous and uninterrupted inaction by the state, my lord. We continuous and uninterrupted inaction by the state, my lord. We are Indian citizens. We hold Indian passports, my lord. We are stuck in Russia. We are fighting a war, my lord, for a foreign state, unwillingly. FIRs are not being registered, my lord. Full-fledged business is going on.
It's gone. We will just look into this matter. Give a copy to him.
Please give me a.
The case of human trafficking.
That
Some
the
people
boys
go
of
to Ukraine.
Punjab, Haryana, Himachal, they are gone now. They say that they are their passports have been.
My lord, they are negotiating for our dead bodies.
Work for the Russian army to fight Ukraine war. God knows what is there, what is truth and what is not.
I will, my lord, this is serious. This is serious.
Give copy to him.
We'll just.
Counsel for the petition directly to hand over the soft copy as well as hard copy of the petition to the Office of Learned Counsel of India, who seeks and granted 2 weeks time to have instructions.
My lord, may make it a returnable notice, my lord.
Lord, the name of Mr. M.K. Maroria be shown. So that otherwise I don't come to know that matter is listed. He is a government lawyer. Grateful.
My lord, may make it returnable within a week, my lord.
89 item.
We are either dead or we are injured, my lord. We are in an extreme situation.
We have asked the Solicitor General to find out.
Obliged, my lord.
May I please, Manoj? Well, this is regarding the Tamil Nadu SIR I mentioned yesterday. The nomination list is not out, though yesterday was the last day. And as far as we are concerned, the supplementary voter lists are still being prepared. I've enclosed everything that I have. I was on the list throughout from 2007. I've enclosed my passport, my Aadhaar, my earlier Epic. I've shown that even as per the earlier election list, my photo is there, my name is there, my address is unchanged.
When was the SIR complete in?
SIR was complete. The list was out in February. Now, when I filed my nomination, I'm told on the 2nd of April, that is now, earlier this week.
Good ground for election petition now.
Manoj?
Good ground for election petition now.
Well, but I filed my nomination. I wanted to file my nomination, independent candidate.
How can nomination be allowed?
When it's
too late
when it's organized political party, they're different. No, Mr. Naidu, you always say too late. I don't understand why Election Commission should get concerned with this. Why do you want to exclude people? It boggles my mind that you want to exclude people.
You'd better address the Honorable Court.
I am addressing the Honorable Court. Why does the Election Commission want to exclude people? It's beyond me. When somebody comes to the Supreme Court of India with every single piece of evidence over the last 15 years, showing that I've been on multiple electoral rolls, I have my passport. I mean, what more am I supposed to show? Passport is proof of citizenship. You should automatically, everybody who has a passport should be on an electoral.
Where were you earlier? Why did you file?
Your claim.
There was, because I've said, and it's noted by the High Court, that I didn't even receive a notice. Not a single notice was received. There's no missive sent to me at all. It's just an exercise of a right. Forget the nomination. I'm saying at least my right to vote.
Sorry, no case.
Very
Deeply blessed.
Good ground for election petition maybe.
But that the ECI will come and say that election petition is not maintainable against them.
That's the law, that's the case.
You must be knowing very well that what is.
I remember Justice Bagchi, my lords, when we first came in July last year, you said that if there is mass exclusion, will be protected. This is what is happening.
Millards,
That's the
unfortunately, somebody sleeps over for months on end,
Very well.
and a single person now says mass exclusion.
I'm grateful.
Political speeches rather than legal speeches. Grateful.
Yes, we there item 66.
May I please, Your Lordship? Your Lordship, the status report mentions that there is a report that has been now furnished and it's before the bench. And the petitioner is here. 6 months have passed, Your Lordship, and his conduct has been exemplary, Your Lordship. I can say that. So, Your Lordship, it needs to be considered in light of what has happened in the last 6 months. He's upheld the majesty of court.
Made absolute.
Sorry?
Leave grant and interim order made absolute. But advise Mr. Pandey is a very.
No, Your Lordship, I've been talking to him. We've had a few cups of coffee as well. So I'm sure that it would turn out to be something positive in the future.
Sometimes there are vibrant, sometimes there are firebrands, and sometimes they're little more than that. All right, now continue to. Now you are a very senior member of the bar there. You need to lead by example the young members of the bar. So they must be closely watching you. The way you will present yourself, the way you will argue, the people are bound to, the young lawyers are bound to imitate. Yes. So therefore you have to lead by example.
Now you lordship, if you lordship find the original document filed by me, blood a lady CM complained that he was abused to mother and sister. She was called prostitute. In that case, my lord, the same judges who convicted with 6 months imprisonment, they awarded only 2,000 punishment, 2,000 imprisonment fine to him. And both the convicts are contesting the election of UP Bar Council. So something, my lord, it is required. That's something to be brought before the honorable court, my lord.
We'll leave it at that, Your Lordship, but we are very grateful for the indulgence.
Right.
Lord, sir, here I need one more week, my lord. I had assured him, my lord, I stand by my assurance, but a week or 10 days, my lord, would be required.
My lords, I have the documents. I can show your lordships out here. It's been, he also has it. Please, just 1 minute. My lords, I can give it to him any number of times. The thing is, my lords, from June we have been out. The High Court judgment has come in September. It doesn't take very long to verify. I have only a suggestion. On the last time, when the lady was pregnant, your lordships allowed us to come back to this one. We can just walk to the border, let them admit us, and then thereafter anything that needs to be done can be done in due process, my lords. We are stuck in an alien land. Whatever has to be done.
I would request my learned friend, my lord, to allow a week's in the.
I have waited very long, and sometimes it gets misunderstood.
As the last opportunity, what happened?
Not beyond this month, my lords.
Resolved, Mr. The request to learn CST and post this packet. It's also there.
Your lordship has posted it on?
We listed some, we have to do some little homework for.
I get it, my lord. So just my request is posted this month.
That's it.
Posted by the end of this month.
April only.
Yes, because.
April only.
Please, my lord. I'm grateful.
1st of May is a holiday, so before that, I'm grateful.
My lord, 68 affidavit has been filed on behalf of Chief Secretary, my lords. In para 5, my lords, we have given how he has applied for the certificate, my lords. And it's in the month of January 2025, he has applied for it, my lords. We have initiated detailed inquiry as well, my lords. My lords, certificate will be, my lords, cancelled after the inquiry, my lords, after conduction of the inquiry. It has been.
How soon you will complete the inquiry?
My lords, pardon, my lords.
How soon inquiry will be completed?
My lords, give us 3-4 weeks time, my lords. It will be done, my lords.
So let we have gone through the affidavit of the Chief Secretary, Government of Haryana. Restricted by landscape council that a fact-finding inquiry is being held. This will be completed in 3-4 weeks. Because this matter for further consideration on some day.
Your Lordship, in this matter, I have issued NOC and notice to the petitioner, and I am not representing because of the misconduct of the petitioners. Because of the misconduct of the petitioner, I am not representing. I have issued the notice and NOC to the petitioner that they can hire some other advocate.
The council for the petitioner very clearly state that on account
Because of their misconduct.
by the father of the petitioner, he has withdrawn his
Yes,
Nama and does not represent them. So, our meeting is the people to continue to question so moto till the inquiry is complete. They are closely watching everything.
Lord, 69 is a very interesting case, Lord. This is a society, this development started in 11-12, sir. We are the first, Lord, society of the home buyers, which is formed in 2013. When this property was not being constructed, we went to Harera in Haryana, that this is not being done. Harera, Haryana, Oris and 3C, both were the developers. Every, Lord, home buyer agreement is with all three of us. Oris, 3C and the home buyer. All agreements are jointly with the three of us.
They have given an undertaking to your lordships. They are now looking to go back on. That is what
your
this case is
problem in
about.
not letting me argue because
My lord, the chief is permitting. My lords, allow Mr. Kassim to complete sentence. He was then will all of you will hear you.
My lords, I appear for a second set of home buyers. I would, my lords, follow Mr. Vikas Singh, my lords, after he completes, my lords.
So,
the dispute is between two associations.
No, Lord. Two developers. Basically, one developer is wanting to take the whole property and not.
That dispute is
any home buyer allotted by the other developer. That's the dispute. Can I just explain? If they give me, Lord, 5 minutes uninterrupted, I'll explain, Lord. They will not permit me because they know that. So, Lord, this society, this development started in 11-12. 13, we were registered as a society of the home buyers. 16, 3C and Oris. These are the three original developers. 3C was to build the property and Oris, the land belonged to Oris. Oris got 35%, 3C got 65%. That was the arrangement between them. We are, Lord, home buyers of both Oris and 3C at that point of time. We went to Harera, Haryana. Saying that this developer is not doing anything. So Harera, Haryana, Oris came. And Oris made an application, an affidavit saying that I will now develop the property because land is mine. It is my responsibility. Harera also accepts that it is their responsibility. And I will give to everybody, both the 3C and the Oris allottees, because 35-65 allotment had happened. About 1,000 crore has been collected for both these set of allottees. This is the arrangement, Lord, in Harera, Haryana, as early, Lord, as in 2020. Matter went to NCLT also. Some collusive petition went to NCLT by the 3C developers saying that I am also a claimant, and he went to that was a collusive petition. When the petition started there, Harera had already entertained the petition. So the NCLT said that in this case, Harera is the
sectoral regulator, and they will only look after everything. That is the order of 3C. And there also it is noticed that ORIS will give to all the home buyers, both 3C and ORIS. At some stage, Lord, 2022, 9 years after association is formed, another association is formed, which is called GWC. GWC is a confederation set up by ORIS. Initially, it had only ORIS management people. We have had proof of record, they were only management people. Anyway, it came into 2022. December 2022, they said, no, ORIS is developing, they should give only to ORIS allottees. So now what ORIS started doing, ORIS blood is giving only to ORIS allottees or selling it to new people and not giving it to 3C. And 3C, this say, will be decided by in the NCLT proceedings. We are not in the NCLT in that sense because NCLT blood is the collusive petition, validity of which is pending here before your lordship. NCLAT said that this is a collusive petition. It should have been not entertained. Your lordships have entertained that SLP against that. SLP is pending here. Civil appeal has been granted. Now, Lord, very interestingly, one individual, goes to the NCDRC. In the NCDRC, he makes a claim that this ORIS also should be made liable. Both the developers should be made liable because there are IRP is trying to not only give it to 3C and exclude ORIS. That is rejected. He comes here in SLP. That order is passed. If your lordship will just see that order, very interesting order. It is at 496. Volume 2, 496. A consent order is passed. IRP, who is colluding with ORIS, makes this statement. Just see that, Lord, 496. This says, Mr. Atmaram Natkarni, learned senior counsel appearing for the R1, which is IRP. I can read, my Lord. On behalf of R1 states that the said respondent has already filed an undertaking before the special court. He submits that interest of appellant is squarely taken off by the said undertaking. Learned senior counsel has handed over a copy of the said undertaking to the bar. This is the order, Lord of Justice Gawai, on Lord X party order on 20th of November, collusive. IRP appears on the very first date or on the next date. The same is taken on record and treated as an undertaking. In view of the matter, the interest of the appellant stands sufficiently protected. The appeal stands disposed of. Now, Lord, this results, we are here before your lordship because this, just see the impugned order now. This results in a filing of a writ petition in the High Court before a vacation bench. 10 o'clock filed, 10 o'clock, 10:30 mentioned, IRP appears and this order is passed. Just see that, Lord, page 1.
What happened to the project?
Project is, Lord, only ORIS is giving it to its own people or selling property. In spite of a restraint order by the High Court, ORIS is selling property to outsiders, creating all parts third-party rights. And in every litigation, they are trying to show as if we are set up by 3C. Yes, if we are set up by 3C, Lord, we are the society who started this whole litigation against 3C. By the other developer 3C. That is their whole case. So I started this litigation in 2017 when 3C was the only developer as per us. ORIS had just given the land, 3C was to develop. 3C, when it didn't develop, we went to Herrera, and Herrera order we have got against 3C. So this order is passed, Lord, in this case. 3C and ORIS. My friend is appearing for some other 3C allottees. IRP contempt notice is issued by the NCLAT. Now he has filed an application in the same writ petition that NCLAT should also be stayed from going ahead with the matter. Just that application I'm carrying, I'll just hand it over. Lord, just see what is the application made. Just see page 1, Lord, the application made, the prayer in the writ petition. I just read to your lordship the order of the Supreme Court in respect of one individual, where an undertaking given by IRP collusively appears and gives an undertaking. The order is passed saying that appellant's case. Now please see the impugned order, Lord, page 1. This is that Greenopolis Welfare Confederation, the one which is set up by ORIS in 2022 December. They were not there in the picture from 13 till 2022 December. Now please see what is the prayer. 3rd January 26 is filed at 10 o'clock. 10 o'clock, 10:30 mentioned. IRP appears on first date and just see what is the order passed.
What happened in the High Court now? It's
pending, my lord.
This order is interim. So what they do, they get this order from this judge. Then they successively...
They give an undertaking to your lordships, they go back on that. Matter is pending there in the High Court. They're seeking to obviate that.
Successively, they move applications for clarification of this order and get it expanded.
This is abuse of the legal process.
Yes.
I'll show where the abuse
undertaking given to the courts, my lords.
It's an interim order.
My Lord, the Chief Justice.
In personam, what is sought to be made in that?
As well as if my friend, Mr. Vikas Singh would permit me.
Just see the prayer in the writ petition, Lord, which is at page 1.
It's a shocking case, my lord.
Yeah, it's shocking.
And what they do, Lord, the next day the roster changes in the High Court. So they move an application for clarification of this order because NCLT is entertained our petition. NCLT says that this COC has never constituted by me. The list of home buyers, you have excluded 500 people without any justification. He is refusing to answer to the NCLT. Then NCLAT Lord is issuing contempt notice against him. So he's made a for subsequent application where he says NCLAT also should be said. Now please see the very first page 1, my Lord. If your Lordship will see page 1, what kind of a preposterous writ is filed.
Mr. Kasim, we will not be able to go into the merits and rival.
Lord, my difficulty, I'll tell you, Lordship, what? The High Court rule says if there is any clarification, it will go to the same judge. So they are repeatedly filing applications seeking clarification and the judge is expanding the scope of this order.
Of a vacation judge.
Vacation judge is expanding this. If the regular bench has to decide, I have no difficulty. Let everything go before the regular bench where the matter is being heard. It is not
High
fair.
Court is hearing the matter on the 21st of April.
I think that is the offending paragraph.
Yes, third, everybody.
So the
Go to contempt.
This undertaking will apply to all.
Even people who are not parties. So when I appear before the learned judge, she says, no, you are not a party, I will not hear you.
Just see para 19. And then again.
No, but what they are doing, Lord, they are again filing an application of correcting this order.
No.
As per High Court rule, it has to go to her again. I have no difficulty with the roster judge dealing with the matter.
We need a
Application after application is being filed for.
Again, the subsequent order, para 23 and para 25.
Yes, yes. Please see. Here, Lord, I appear. She says, I will not hear you. I personally appeared. She says, I will not hear you because you are not a party. I am appearing for the main housing the residents association. She says, I will not hear you. And she passes a second order. Now there is a third application filed which says restrain NCLAT also from passing. This order says that the restrain NCLT, all authorities will be bound. Just see, Lord.
My lords, your lordships may give me 2 minutes after Mr. Vikas Singh. I will explain the matter slightly.
Just see paragraph 23. In view of the aforesaid, in the next order, Lord, at page 17, in view of the aforesaid submissions and upon due consent.
Colluding is
going on.
Subject matter. The subject matter roster is with whom?
Justice Bambani.
Bambani.
We have no difficulty. Let it go before, everything go before Justice Bambani. I have no difficulty.
April 25th.
It can't be that some application keeps going there and
It's from my lords. Let me explain. Basically, my lords, there are 1,100 home buyers to whom 3C sold flats pursuant to this joint development agreement. Under the joint development agreement, 3C paid 196 crores to this Oris company. Oris was the landowner. Oris took, my lords, the development certificate from the Department of Town and Country Planning, Haryana. Thereafter, the arrangement was 3C would construct all the flats. They constructed, my lords, 90% of the first phase, 60% of the second phase, 40% of the third phase. I hope, my lords, I'm clear. They also siphoned off large amounts of money. So we were cheated, my lords, by 3C because we took the flats from 3C out of the 65%. They, my lords, sold to 35%. Now what happens is 3C, after having siphoned it off, tries to enter into a collusive IBC proceeding. My lords, give me 2 minutes, my lords, give me 2 minutes. Your lordships will understand the magnitude of what is happening. So then what they do is, they go ahead, file this collusive IBC proceeding in which they seek, 3C seeks to escape liability for giving the homeowners flats. Till now, my lords, we are still entitled to flats because 3C, under the IBC proceeding, the IRP would have had to go ahead, take over the project, complete it and give us flats. This has been the law, including in Pioneer, my lords, which considered the constitutional validity of the explanation by which home buyers were made financial creditors. Now, my lords, Oris decides in a conspiracy, my lords, to go ahead and take over the entire set of buildings constructed by 3C, give only to themselves.
So escrow amount, our escrow amount is also given to Oris.
So
our money.
753
crores.
700 crores has been spent by 3C out of our money. 196 crores paid in advance to them by 3C in order to take over the project. Now what Oris decides is Oris will only give, that is Oris will ensure in the IBC proceeding we will only get money and no flats. So, my lords, they undertake a set of proceedings, my lords, across the board. They have deep pockets. They go to the High Court, my lords, in a separate writ petition where I'm appearing, where they take orders, my lords, from another learned single judge, which says that we will be only entitled, my lords, to money, not flats. We, using, my lords, that single order of this honorable court where one buyer accepts the money. They also, my lords, have the IRP file an application before the special judge who is seized with a PMLA proceeding, which has taken over, my lords, the money, the siphon of assets of 3C and say, I want these assets so that I can give money to these people and nothing else. This order, my lords, is done in a vacation bench on the 3rd of January. When they know that the roster is about to change, they approach this learned single judge. And then they take this order in which they say all buyers, all fora will be bound by a Supreme Court order in which an undertaking is accepted from the IRP to pay one buyer, and the special judge's order saying that the assets shall be given to the IRP shall be binding on us. This, my lords, is a set of proceedings designed to ensure only one thing. 3C buyers don't get flats. We want only our flats. We will only be given money, that too out of the insolvency of 3C, when in fact 3C and Oris signed all the home buyers agreements saying that we will be given our flats. And my lords, 3C was given a power of attorney by Oris to sell the flats. Today, they want to disown responsibility for this and confine us, my lords, only to money.
And the IRP has accepted Oris claim as 80% holding in this proceeding there also.
Shockingly.
So really speaking, there is no money coming to us also in those proceedings. Because the same IRP.
What is the next date?
April 21st.
21st.
Justice Apani, who's been hearing the matter.
Application before the other judge was
3 minutes.
even NCLAT has issued contempt notice against the IRP. That proceeding also is sought to be stayed. This is the application which is being listed. On 16th, before this.
This is
No, nothing. Not at all. Not at all.
And Justice Ashok Bhushan's bench plot has issued contempt notice. He wants contempt notice also be stayed by this same single judge.
Case of abuse of process, my lords, across the board.
The same IRP has given 80% share to Oris.
With whom?
Justice Ambani. Because could your lordship give me a minute? If they have finished, because I am appearing for the writ petitioner. Now, may I request the court please to go to page 806 of volume 2, which is P43. I don't want to get into it. To answer your lordship's question, the next date of the writ petition is on the 21st of April. It is coming up before the roster bench.
So no clarification should happen in the meeting.
It is coming up before the roster
no
bench.
difficulty with that.
The roster bench has issued notice on the SLP petitioner's application for impediment and also on the application for dismissal of this writ petition. The next date is going to be 21st of April. So, and it has been fixed, I'm told, at 3:30 in the afternoon.
And is there another application going before the original judge? Where they want NCLAT proceedings to be stayed.
No, vacation judge.
The grounds are identical to what they have raised here in the dismissal petition. Now, my lords, the learned single judge, which is the roster bench.
What is the number of the main case which is now before?
The main case is Writ Petition Criminal 2 of 2026. And there are there are various miscellaneous applications and IAs which they have taken out, which are also listed.
All right, right down.
This is a shock. Process, my lord.
Third line single counsel for the parties at a considerable length. Next paragraph. The interlocutory orders under challenge passed by the High Court of Delhi have arisen out of writ petition in bracket CRL number 2/2026 and various applications moved therein. Next paragraph. The above stated writ petition is now listed on 21st April 2026 before Justice
Bambani, Anup Bambani. Anup
Jairam
Bambani.
as per roster.
As per roster.
Next paragraph. You are not party there in the.
We have filed an
impeachment there.
We have filed an impeachment which is also being
My
considered.
lord permits, may I say something, my lord? May I say something, my lord? If my lord permits me, my lord. I am for the ED. Two things.
Necessary and proper parties to be heard by the High Court. Consequently, their application for impleadment shall be deemed to have been allowed.
Very well.
The next paragraph. Since the main case is still pending before the High Court, we do not express any opinion on merits, allegations or cross allegations made by the parties. All that we deem it appropriate is to request the learned judge to make an endeavor to take up the main case on the date fixed, and wait for final disposal. The learned single counsel for the party assured that full cooperation.
Yes.
Shall be
IAs also will go there only, bro, because they are filing IAs of clarification.
There are 4 IAs before your lordship.
Integrity of a judge like this, my lord, which are loose statements.
My lords, I appear in 1 IA, my lords. That may be also allowed, my lords.
Meanwhile, if any interim applications have been filed
Yes.
in the main case, the same shall also be listed before the Chief Justice of the High Court is requested to list such applications also before Justice Bambani.
Grateful. Very grateful.
As per the any order on those applications may be passed after hearing both sides.
Deeply obliged.
So grateful, my lords. Grateful, my lords.
I think
Grateful.
ED also
May I
wants to say
submit now, my lord, something, my lord? But may I submit two things?
Shocking has happened even against the ED.
On the third, when the application was moved, there was no urgency. Despite that,
He says
the
ED is also
application was
collusive,
moved
my lords.
before the
Everyone
learned
is collusive.
judge in vacation. Number two, when we said we are objecting, it was stated in the second order that we have not raised any objections. There are two things. Thirdly, my lord, my suggestion is let a retired Supreme Court judge be appointed to verify the genuineness of the home bias. And he
I
will
think that will
decide.
be appropriate. We are all not by the time this whole thing is decided.
The case is
Make this clear before the learned judge of the High Court.
Yes, correct.
My lords, great.
He will decide the genuineness. Infighting will be avoided, my lord.
And we will get nothing.
My lords, as of now, may I tell the learned Chief Justice, my lords, as of now, what is happening, my lords, is another learned judge who is now retired of the Delhi High Court has passed an order, my lords, where he has effectively stayed the Herrera orders. Herrera had said status quo and allotment. That learned single judge has interdicted Herrera from proceeding. Under cover of that order for the first time, which is March 25th, 2025, they have gone ahead and sold our flats, my lords.
That's not correct, my lords.
And when we come here,
against
that order, your lordship.
No, but that order has been set aside by the division.
No, the
Spending, my lords. Spending, my lords.
When we come here, your lordship is
spending.
The High Court.
So that is why I think
I'm sorry, I must mention this, that the LPA is pending.
Just a minute. At this stage, Mr. S.V. Raju, the Additional Solicitor of India, representing the Enforcement Directorate, has suggested the appointment of a former judge of this court as the monitoring authority.
we do not express any opinion in relation thereto and leave it open to the enforcement directorate to make such prayer before the honorable hand.
Would be deeply to be considered on its merits, not because they are distorted facts, not to present a version which is untrue. To get this order which is not maintainable.
It's okay.
Very deeply obliged.
Malats, this order of the single judge, this order.
It's a very gross order. It should be stayed.
Must be stayed, my lord.
No, absolutely not.
Because
Vacation,
a vacation judge on the first day over his objection.
Not we will oppose it.
Today we are already, it's a 10 days matter.
Yes, yes, ma'am.
Very well, Malats. I'm grateful.
Grateful, Malad.
Yes, item 70.
May I please, Malats? Malats, this is about the expansion of a coke processing plant, Malats. MOEF grant me approval and recommend that the terms of reference are issued that I can go ahead and process the pet coke. First of all, pet coke is neither banned nor prohibited. Only the quantum is regulated, and that is regulated through this order, this court's order. I'm not asking for either an allocation. Allocation has been done, and I use and I process that coke, and I send it for the aluminium manufacturing purposes, which is not in dispute.
Thank you, sir.
What happens is this honorable court cast responsibility on CAQM, say that you monitor how it is 1.4 million of coke is to be used. Based on that, the recommendation which has been given by MOEF, which is the competent authority to go ahead and settle it, is the COAM says that no expansion should not be given. Now, there is no basis or no reasoning has been given except to say that the quantum of import and the processing of it is regulated by this honorable court 1.4 million. I have no difficulty. I'm neither asking for any allocation, not asking for any other that I should have a priority over others. Only I'm asking is the quantity which I have allocated I can process, and this quantity of 1.4 million is to be changed over a period of time because that's the leeway this honorable court has given. There is no option of a pet coke for aluminium manufacturing, and that has been now proposed to be enhanced to 1.9 million, and therefore I'll get the due allocation. CAQM has no authority outside the Environment Protection Act. MOEF once has granted, the CAQM, which is the only a competent authority for NCR region, draws authority only for allocation, nothing else. Therefore, based on that order of the CAQM of 15 to 20,
to take a call.
Well, the MOEF recommended in my case, which is at page 246.
No, they have recommended, then who is to take the final call?
Well, the MOEF has to take a call. They have to consider. CAQM cannot override the jurisdiction of the authority of the MOEF, which is the competent authority under section 3 and 5.
MOEF gave you TOR.
Yes.
After the order of CAQM freezing.
Yes.
All the activities requiring PET or the import of RPC.
Yes.
By order dated 15 to
2024. Yes. Yes.
Your TOR, that's the reference order.
Yes.
By MOEF comes on 24th of March, which was after the CAQM order and was not noticed.
I'm grateful.
Was not noticed.
I must clarify. I'm grateful. That's a very, very relevant question, Melissa. I'll give 2 dates. First, the MOEF where they give me term of reference and agree with my proposal is 29 to 2024. I hope that's at page 238, Melissa. Just 2 dates. So 29 to 2024 is when I'm approved by MOEF and the terms of reference are given. Then comes the order of CAQM is prior to that, which is 15/2/2024.
Mr. Singh,
Yes.
you have twofold argument.
Yes.
A, jurisdiction of CAQM to put a complete injunction
Yes.
on your activity.
Yes.
And B, whether you were an ongoing augmentation concern.
Yes.
Taking the second first,
Yes.
your TOR comes after the CAQM freeze and therefore cannot be treated as an ongoing concern, subject to hearing.
Absolutely. I'll submit to that.
With regard to your first contention that CAQM is going beyond the mandate of the Supreme Court or the order
The authority
of the
given
Supreme
by this
Court,
honorable court.
considered it from two angles.
Yes.
Court limited it with regard to monitoring the use of RPC for various industries, including the PET industry, aluminium industry, and other lime and other industries.
Industries which were there. Yes.
So
yes.
it incidentally
Yes.
vests CAQM, which is an authority under the Environmental Protection Act,
Yes.
with the power to regulate the activities which will use this nature of coke by way of importation or otherwise.
Yes.
Secondly, this CAQM order is pursuant to a subcommittee of which the Ministry of Commerce and Industry,
Yes.
the Director General of Foreign Trade are representatives.
Yes.
So
Yes.
it cannot be said
Yes.
the alien to the sovereign powers of these respective departments who have regulatory power of import.
Very well, Malaz. I have no. Kindly allow me to answer both. And the second first, Malaz. So far as my proposal, Malaz, just to I'll answer both in law, Malaz. So far as the first aspects is concerned, the MOEF has taken a decision on 29/2/2024. On that day, the order of 15/2 CAQM order was existing. So CAQM said that the fresh expansion not to be given based on a committee which was formed. Committee never, which is on record, committee never said that no expansion to be made. Committee only said 1.4 allocation, how it is to be done. So it was not, there was a subcommittee's report on record. I can show that, Malas. Committee never suggested that don't expand because it takes 8 years for a plant to come, any expansion, because first is goes through the process.
Come to page 229.
229.
236 also it says that
229.
fresh expansion is completely prohibited in this.
Malas. 229, Malas.
Sorry, 230.
236, Your Lordship.
230.
Top of the page.
Kindly allow me, I'll come to everything which is relevant. If my lords may see.
Come to paragraph 7. This is the subcommittee recommendation on future import.
Yes, Malas. If we see the para 7, yes.
Para 7.
Para 7. With regard to the issue of future import of RPC and CPC in the country, the subcommittee observed and recommended the following. Irrespective of geographical location, all the calciner industries which have obtained all due statutory permission and clearances for the prescribed production capacity of CPC need to be treated at par as far as the allocation of import of RPC is concerned. So no difficulty. I'm not asking for more quantity. The calcining industry involved in the processing raw pet coke to calcine pet coke is a feeder mainly for anode manufacturing for the aluminium processing industry besides other miscellaneous industries applications. The conversion of RPC to CPC, however, is associated with the substantial air pollution load since the sulfur content is so-and-so, so-and-so. Next line was, the aluminium industry also has an option to direct import some quantity of CPC required for processing, which obviates the incremental pollution load owing to the conversion process from RPC to CPC. Thus, the further capacity enhancement expansion of purely calciner may not be encouraged. This is only for aluminium. It's only because aluminium has separate allocation. Just to make it clear, 1.4 million is only for calciners. 0.5 million is for the aluminium industry. So they say, I'll come to that.
Industry, thus further capacity of enhancement, expansion, purely of such industries may not be encouraged. Same thing.
Industries is
Today, what I'm saying is,
it is not that the CAQM acted in a manner which was arbitrary or without guidance from the respective departments which are entrusted with the duty of regulating import.
What are the two things which in this? Well, on a MOEF has clearly agreed that this is a case of a recommendation, page 245. Kindly see what the observations.
Wriggle out of that.
No, this.
Lordship, while your
No,
lordship,
the
that
MOEF today is also not. The MOEF has not rejected. MOEF what simply says is the CAQM and the CAQM is objecting to it. That's why therefore we withdrawing our. They're not saying that this is not required. It is not a post facto case. First of all, I'm in compliant in all approvals are there. My EC for the existing capacity is there.
Question is only of capacity. On capacity, there is a specific finding in para 7.3 and 4.
Kindly see page 245 on my capacity expansion. First, the MOES finding, page 245. Where the committee deliberately considered, and when the committee consider, it goes to the State Pollution Board, the CPCB, then all the authorities, page 245, on the middle of the page, serial number 3.6.4, deliberation by the EAC in the current meeting. My lords, I hope page 245, middle of the page. The deliberation by the committee. I'll read the first one. The instant proposal is for expansion of the existing calcinite petcoke plant of so and so by installing so and so. Then they consider everything, and if kindly go to the next page, 246. 2.3.65 recommended. It was after all examination. It doesn't happen that first they call reports from all authorities and they do it, Malats. So therefore, state recommends. Now, how it has been withdrawn, kindly see that. And the one line, Malats, this is the page with MOEF's 57th meeting, which is at page 256, Malats. Only one letter written by CQM, and I'll come to the competence of CQM later, Malats, just to clarify this. Page 256, top of the page, para 3. Now, how this turns is para 3 on page 256. EAC notes that they have just received a letter of CAQM dated 19/4/2024, which is at 248, and concluded that the proposal was evaluated after the issuance of an order dated 15/2/2024. It is apparent that such a proposal cannot be cleared in a compliance with the direction of this honorable court. Factually wrong, Malats. I'll show this honorable court. The project proponent has neither submitted the details nor presented the same before the EAC. Therefore, the recommendation made during 55th meeting held on so and so should be withdrawn. That's all. Kindly see two things now. Supreme Court's order, Malats. What Supreme Court directed CQM? CQM is the authority under a specific act.
Understand there is no position of the Supreme Court that there cannot be any expansion of the calcification industry. Even the CAQM recommendation is not a complete bar. Entities of ongoing augmentation project who have been granted consent, etc., have been included.
Please.
The thing which weighed with the MOEF now,
yes,
now, given the TOR, without looking into the CAQM observations, and that is why they recalled it.
I'm grateful. Two things, Malats. First of all, just to make it under the law, CAQM has no authority to look into any project outside NCR because that's the authority they have under the Act. This honorable court gave the authority to CAQM to check only one thing. Only one thing. That is the allocation of 1.4 million import which has been done. Well, the project of West Bengal, central government saying the project can be expanded. The product is not barred. EC approval is already there. No. It's only a capacity. I'm not saying it should be granted. But all I'm saying is CQM, which has no authority otherwise, drawing authority from this honorable court's order. And kindly see what authority, because in law they have no authority. Malats can take it to the law. It's very clear. The air quality check in the NCR was for the purpose of which the act was created. What authority this honorable court granted is, kindly see page 200. Because if they start, if these...
We have seen that. The thing is, if you read it literally,
please, Malats,
it means 0.4 metric tons of
the petcoke
was imported,
yes.
1.4 was being allocated. There were 6 industries who were getting the allocation,
and that is
one of some other industries wanted allocation.
Yes.
So they they wanted further import. How will
Yes.
that be allocated?
Yes.
Now, in that situation, the Supreme Court said the best authority is CAQM.
Yes.
So they can do this. Existing in situ import will be distributed equitably,
Please, Malas.
keeping in mind
Absolutely.
the first 6 already
Those are
allotted.
industries are there, yes.
And 0.4 can be distributed amongst the other competing or other aspiring industries.
Yes.
At best, we can permit you to go to MOEF again.
Go back
It
to
is-
where
The, I have, Malas, I'll follow whatever. Ultimately, I have to bow down, Malas. Malas, the only issue is it's a very today. If the government think this to be banned, perfectly all right.
We are
The
already
government is.
struggling hard and with this all pollution issues and.
Malas, it's not the government is not stopping that. Malas. I'm saying I'm complying. All I'm saying is the authorities like CQM, which has been created for specific purpose to deal with a specific area in law, the parliament has given a power only for limited purpose. I can understand the court thought is.
Let the MOEF take a call, that's all.
Lord, can we just show one page where we
Malas,
very clearly.
Just last submission.
Please.
Well, only on this aspect, as I said, in 2023, Government of India took a conscious call that this product is imperative for certain type of manufacturing. Therefore, what they did was they prescribed a norm through a central government notification.
they are not stopping, closing your doors.
Yes.
You go back to MOEF.
Please, Malas.
Make out your case in light of the CLQM
Order.
So I'm grateful.
In spite of CLQM order, MOEF gives you permission.
I'm grateful, Malas. I just one last request on this. Yes. Malas, just last submission on this. I'm willing to go back to the. Just one.
Lordship, may I just make
Malas,
one
just say-
submission
I'm
here?
sorry, just lastly, Malas, I'm bow down and I'm agreeable to the position that I can willing to go. Only one aspect that today the understanding of MOEF is coming from the second meeting is that since the MOEF has the Honorable Supreme Court has completely barred the expansion because the languages say that Supreme Court has said, which has not been done. The MOEF should take a call independent of that position if under the environment law and the policy of Government of India, this is a.
MOEF has not said that we have barred.
No, that's the language. I'll just read the one line from their meeting, which is at page.
You are agreed by 248 letter, last line of the first paragraph. The order inter alia prohibits establishment of any new CP manufacturing unit.
Yes, so that's the understanding. That's what I'm saying, Malasi.
You are agreed by that.
Yes, so
that is not there in the Supreme Court order. It is prohibition proposed by CAQ.
well, they are deriving it because page 256, they clearly they say compliance with the direction of Honorable Supreme Court. Page 256, third line. That's the understanding which otherwise, Malas, I have no problem. Whatever they tell me to have a compliance norm, I'll comply with that. And today, Malas, what happens is once I'm sorry. Supreme Court has not prohibited anywhere. Government of India, after the order of the Supreme Court.
Seven also, they don't say because of the Supreme Court order that we
No,
can't.
they are saying with recommendations, Your Lordship.
Exactly.
It is the letter of the CAQM on basis on
But
which
today-
the TOR was rejected, withdrawn rather, not rejected. Lordship, may I just show?
Mr. Singh, if you see page 256.
256.
The rejection or the recall
Yes.
is essentially on the ground of non-placement of relevant materials for TOR. And according to the ministry, the CAQM order was a relevant fact in your knowledge, which you should have. And that is why it says that we are recalling it. So let them re-examine.
Well, 29 to 2024, after a comprehensive hearing and production of document in front of a committee which was fixed.
CAQM order was not placed before the
No,
ministry.
I'm not saying, the only issue is I'm not saying that whatever the compliance condition to be done. Well, once the commodity which is to be reviewed, if tomorrow the Government of India says that no, we need more aluminium manufacturing in the country, pet coke more is to be imported. 8 years it takes, well, the whole process to set up a plant. 8 years. Today to say the commodity is permitted, the party is not asking for allocation. I'm willing to go to MOEF to say, please put condition, I'll comply with that.
That MOEF examination.
Lordship, I have only one problem here. The MOF was part of the subcommittee. The subcommittee, may I just read 2 lines for your lordships, where it clearly bans expansion because the requirement, there were clear instructions from this honorable court that the interests have to be balanced. Now, may I take your lordship just one page, please? Lordship, may please come to page 234. What has transpired? It says the observations, deliberations, recommendations made by the subcommittee were shared with the commission members. The commission approved the recommendations of the subcommittee. Now the directions were given with regard to import of RPC, CPC by calciners and aluminium industry. Point 1, import of total 1.9 MMT RPC for CPC manufacturers and 0.5 MMT CPC for aluminium industry respectively shall be permitted during 2024 and 25, and 1.9 MMT for calciners and 0.8 MMT for aluminium for 25 and 26, subject to the following conditions. Lordship, may please come to page 235 bottom, 236 top rather. This is important, Lordship. The suggested caps on the import of respective quantities of RPC, CPC is considering the present capacity. This is what was weighing with the commission. It is considering the present capacities, consents of the regulatory authorities, including ongoing manufacturing, capacity augmentations, and expected to take care of the requirements in all the sectors for the next 5 years. And thus, ordinarily, a review would be required accordingly, except for emergent and unforeseen conditions that may arise in future. Accordingly, Your Lordship, may please mark this. Accordingly, any new establishment of CPC manufacturing unit or capacity augmentation of existing calcining units shall not be allowed purely in the overall interest of the environment. Now, Your Lordship, this order was in the knowledge of the petitioners. There was a duty cast on them to have told the MOF about this. They chose not to do it. Now they can't cry horse over here, Your Lordship, with great respect.
No, the sound is, how do you expect them to?
Counsel for the petitioner at a considerable length as well as land counsel. You are present CAQ.
Lordships.
As well as counsel for CAQ. But we do not find any error in the order passed by the National Green Tribunal Principal Bench. Our liberty is granted to the petitioner to approach the Ministry of Environment Research, MEF, who may take an appropriate decision with respect to the appropriate reason for the on the first proposal for extension of the production capacity of the petitioner from 1.27 lakh tons to 3.99
Yes,
lakh tons per annum. We have no reason to consider let the MOEF take an appropriate decision after hearing all concerns. And keeping in view all the relevant considerations.
Lordship, me just
But just
indicate
factually-
keeping view the, sorry, sir, order of the subcommittee, because that will be very relevant.
Correct. That is why we are
That-
saying relevant consideration.
Would your Lordship consider just writing the date of the subcommittee order, because that's the only thing that will be relevant for them to decide whether it's permitted or not.
Said all relevant considerations.
Your Lordship,
just-
leaves a lot of room
the-
for interpretation the other way also.
So the MOEF is the competent authority.
It is mentioned.
Are not, we have,
I leave it to your Lordship.
we have observed fresh application.
I leave it to
So
your
they
Lordship.
make fresh applications if there is a change, if there is a change of policy of the Ministry of Commerce and Industry and all.
Bow down. Then it's fine.
Just factually clarifying,
grateful.
so although the order is dictated, on 29/2, when the this was given, all the order was, my instructions are, order was there because the gentleman who participated when the CAQ meeting was there, he was the person in the meeting when the 15/2/2024. So it's not that the order was not available on that day.
But that's the finding of the MOEF.
So that's that was
Try your luck if the
Grateful.
ministry agrees to enhance the capacity, it's fine.
Grateful, Your Lordship's obliged.
Grateful.
The pass over item 87. Yes, Mr. Jain.
May I please, my lord? I'm sorry, I was not there in the first round.
No, it's all right.
If your lordship just see page 65, para 9 of the judgment minutes, which is Vikas Kishan Rao. Vikas.
Your adjoining state has gone for election with 27% OBC.
Means
We
what?
have permitted.
What your lordships have already held is the two things which have
Which was a statute which came into force in 2023,
yes,
which was to challenge in 2025 when the elections are just nearing.
Let's kindly just see what has happened here, Millet.
Process is on.
So far as here means they notify the issue notifications only when the process is still underway. The High Court records that the process is underway. And it is straight in the teeth of both the judgments of your lordships, my lord, as well as the order of the interim order in the Maharashtra case which your lordships have passed. Just have a look at that Maharashtra case also, which the High Court also notices. Just see page 103 at 111. Para 5. This is the interim order which your lordships passed. Consequently, subject to the outcome of these proceedings and without prejudice to the issues raised on behalf of the rival parties, we deem it appropriate to issue the following directions to the State of Maharashtra's Election Commission. The election to the local body shall be notified by the State Election Commission within 4 weeks. The reservation shall be provided to the OBC communities
Here you are asking the reverse relief. There people came to us seeking direction for holding the election. We directed.
Correct. So now here, please, what happened was that the stay that was granted was originally when the stay was granted, it was a blanket stay. Why? Because contrary to both the orders, the earlier order of the Constitution Bench as well as in Vikas minutes, they were continuing with the same thing. So the order was passed was as prior to.
Where do you say that they are crossing the benchmark of 50%?
No, it is not a question of 50% only. It is not a question of 50% only, Millets. Just have a look. That's why I'm saying, just have a look at.
Sequence order in Maharashtra, which you are referring to, clearly says up to 50% allowed.
No, just see, first see 2 minutes. Just see para 2 at page 112.
Yes.
What it says is the reservation shall be provided to the OBC communities as per law as it existed in the state of Maharashtra prior to the 2022 report of the Bantia Commission. Now, so therefore,
But in your case, the law has been enacted.
Now what has happened here is that as far as the report of the commission is concerned, there was an earlier commission's report which was there. Now that commission's report, the state themselves says that it is bad. Therefore, a subcommittee was appointed. The law that is enacted is not as per the commission's report, but as per the committee's report. And now they have set up a new commission, and the High Court notices in the impugned order that the new commission process is still underway. And just see what needs to be done. Just have a look at para 9. Today, this benefit is to be given to whom? The identity of the person.
When was the act enacted, sir?
The act was enacted. Your lordships have said that it is still an enabling provision. The act is also an enabling provision. What needs to be done is the effectuating it will come in the notification which came only in 2025. Just have a look at, that's why I'm saying, just have a look at para 9 of that judgment in 2021. Just have a look at that. Page 65, para 9. Just have a look at that. It's page 65, para 9.
Yes.
What it says is, besides this inviolable quantitative limitations, the state authorities are obliged to fulfill other preconditions before reserving seats for OBCs in the local bodies. The foremost requirement is to collect adequate material for materials or documents that could help in identification of backward classes for the purpose of reservation by conducting contemporaneous rigorous empirical inquiry into the nature and implication of backwardness in the local bodies concerned through an independent dedicated commission established for that purpose. Thus, the state legislation cannot simply provide uniform and rigid quantum of reservation of seats for OBCs in the local bodies across the state, that too without a proper inquiry into the nature and implication of backwardness by the independent commission about the imperatives of such reservation. Just, Manish, kindly just see. Manish, kindly just one more aspect, Manish. Just have a look at it.
Ensuing election shall be subject to outcome of the proceedings pending before the.
But just one more thing, let's just one more. Just have a look. What the High Court has also done is, means I had filed an impleadment application before the court. The court has rejected my impleadment application also. And it is in the street. And if your lordship may just also say that it can be heard and decided finally early. Because if in the 2021 judgment also those elections were set aside ultimately.
We don't control the High Court process.
2000. In the earlier round, in 2021 also the elections were conducted and they were set aside as a consequence of this.
Thank you, Mr. Jan. Thank you. Item 71.
Please.
Well, here the
My lord, in this matter,
has given its affidavit with options. If your lordships will just take the counter affidavit of respondents 2 and 3. This is in compliance of your lordship's order. Your lordship sees page 27.
No, the position is like this. I must point out.
my lord, before my learned senior opens, my lord, I am appearing for respondent number 5 municipal council, my lord. My affidavit is getting ready, my lord. I have to just give me some breathing time.
Their
So that-
affidavit is not necessary, but I'll point out. Municipal council's affidavit is not necessary. My lord, please come to page 26 of the MA. Your lordships were pleased to pass this order. That this is Gajanan Sansthan, Gajanan Swami Sansthan, revered saint, my lord, and saint. Many people come. It is a question of expansion. Your lordship's order is page 25. At 25, para 30.
Open it, put your iPad.
Lordship gets, my lord? In this regard, we clarify that if there is any space available within the project where the petitioners can be accommodated, their claim will have to be considered on a priority basis. We say so because mindful of the fact that petitioners have also fairly undertaken not to seek further enhancement in compensation if they are adjusted. But there was an enhancement granted by the High Court. We accordingly dispose of these special leave petitions, upholding the subject acquisition as well as judgment of the High Court to the extent of granting additional benefit to the petitioners. Please see this. In addition, we direct that claim of the petitioners for rehabilitation under the project, out of them at page 94, there was a photograph given of the rejoinder be considered fairly by respondents, and if the authorities decide to adjust them under that project, the petitioner shall not be entitled to seek further enhancement. Moreover, we clarify that if the suitable shops are not available in the above stated project, the authorities will make immediate alternate arrangement for rehabilitating the petitioners in the same vicinity. Now, my lord, our affidavit says that in this page 94, inside the premises, there is no space available. In any case, that's not for rehabilitation. there is a land provided and a shopping complex constructed 400 meters away from Lord this Sansthan. It's available, they can take possession tomorrow.
Yes, option 2 is okay.
Milord, so far as
The building they have shown, Millards, in the development that has to be demolished for the expansion of the temple.
No.
The
this
very
is not-
purpose
This is the new
is
building.
entirely different.
The purpose appears
Naidu
to be
is wrong.
installed
Page
the
94
enhanced,
is a new building.
And actually, it's been represented to your lordships that that was project meant for the rehabilitation. It is not. What's been assigned by the municipality at 400 meters, that is meant for that. A government resolution was passed to that effect.
Build the wall.
Their shops are available, they can go and occupy.
Milord,
I they wasn't allowed to open because they were making the submission.
Milord, may I submit?
Take your lordship
All
this
the
page
meeting,
itself.
they didn't come for the meeting.
Two.
The purpose appears to be no expansion. That's what appears to be the purpose.
Now,
And out of hundreds of people, no, these are 10 or 15.
589, 569 vacated and rehabilitated.
Yes, and they are
Only 20 are holding on.
At the outset, it is stated by Metal and Council representing the
state of Maharashtra. Manoj.
state of Maharashtra.
may I say, Milord,
I am for the sixth respondent, Sansthan.
Milord, I am for
Concern, sir. Council is not.
Option 2. So what? For rehabilitating.
I just one suggestion rather than pushing it off, we can finish it off today. Option 2 Is we have acceptable. taken in instructions, which is what the solicitor said, that 400 meters away, etc. I've said instead of keeping on pressing and breaking our heads against a brick wall on this, let's go with that option 2. I think it's a very fair suggestion by them. We'll go with the option 2. Only one small reservation is that the size of the shops that were available to us, which are there in this option 1, if it's available, but if it's not available, the size of the shops is something that we are concerned about. So in option 2, this 400 meters away, where these shops are available, which they are offering, we'd be happy to take On it. ownership basis. On ownership, obviously on ownership basis. We are the owners because we are not, there are some other encroachers, there's a separate scheme, we're not concerned with that, we are the owners. We just, our understanding is that we'll be given the same size shops as the ones that we are losing. That's the only That's the concern. only thing. Yeah, otherwise, option 2, completely agreeable.
That's a fair thing. Whatever size shops are given to similarly situated people who vacated, it will be given.
Commensurate to us.
Shops are been now constructed, now.
Yes. No. So from where we vacated, which is that rejoinder page 95, shops have been constructed. We asked for that earlier. We understand that now it's been occupied and nothing can be done with it. Or they don't want to allot. So we're letting that go. Option 2, which is the suggestion that has come, I'm just handing over that as far as we are concerned, these are the sizes of the shops that we had.
No, but depends, the point is that had it been under construction, the size can be varied. But if the already project is completed and it's ready to move.
No, so if depending on the size, suppose for example, I'll just give you an example. One of these shops is 113 square meters, which I had. Now, if they're existing, I don't know the size of their existing shop. If their existing shop is 30 square meters, you'll give me 3, which will be commensurate to it. That's all. That's all I'm saying.
We'll have to treat everyone equally. Those who have
Yes.
obeyed the law and vacated.
20 of us have come.
20 of us are there.
20 of us have come.
That may create complication because others also suppose if for 60 square meter, if they have been given, let us assume.
Yes.
Top of only 30 square meter.
Yes.
They will also ask for them.
No, as far as we are concerned, that your lordships can bring the guillotine down because we are the ones here agitating, only 20 of us.
This is vacant.
Yeah.
14. Only 14.
Yes. 14.
19, 4 have been found to be enclosure, 1 is a residential entity,
So
already accommodated.
we are asking only for the owners.
Only for the
14 of us, only the owners.
14 will get in option. Milord,
No, so then you have to clarify. Ye 12 plus 8.
What happened? Council, right?
I have to add.
In the first SLP, your lordships are right, it's 12 in the first SLP. There's a second SLP, my friend is appearing. There's 8 there.
20.
So it's only that. We have given the names.
We are seeing the affidavit filed in SLP 10396.
Yes, Milord. This is the counter of the respondents of. Yes, Milord.
But it just speaks of 19 persons.
19. 19.
You see, they have given the breakup.
Yes, 19.
Is that correct? 19, yes.
19, not
19, not 20, 19. Yes.
page 1920,
Yes.
paragraph 26.
Yes.
Clarification stroke clarification.
My lord, only one submission I have to make. My lord, I being the development authority, the chief officer of municipal council. It is the premises of municipal council. There are three hurdles. First is section 92 of the Maharashtra Municipal Council.
We will sort, I am the state, we will sort out all hurdles.
Yes, only.
Don't worry, the
Even
chief officer need
that
not worry about.
even that will not complete. Even first state approval is there, that is required under section 92. Read with rule 8, 1 and 2.
They are reporting statement of the state.
Yes, Malad, that's.
Three things, Milord. One is state's approval. State has already delegated powers to collector, no difficulty. Secondly, now the body is elected. So the 2/3 majority of the municipal councillors.
I think if the state is getting a statement.
Just wait.
There is something
And
else
third,
going on.
and third, there has property disposal rules 1983 says.
Council and the state government.
No, I am not.
Political
I want
executive.
that your lordship
Or
may take
different
decision
political
considering these submissions, nothing more than that. There has to be auction, that's all.
Tushar Mehta Land Solicitor of India representing state of Maharashtra as well as other land council. This also should be stated here. That board or Sri Gajanan Maharaj Sansthan and the Municipal Council. In clarification, stroke modification of paragraph 13 and 14 of 13, 14 and 15 of the order dated 17th February 2026. We place on record the statement of the Tushar Mehta Land Solicitor in India to the effect that a rehabilitation project has been that there is a project complete in all respect, which is hardly 400 meters away from the open dispute.
Not at Gandhi Chowk, page 132, option 2, my lord.
It's Gandhi Chowk.
Completed at Gandhi Chowk, which is situated on the main road of Shegaon city, located just 425 meters from the site acquired.
Gandhi Chowk.
Yes.
Which is situated on the main road of Shegaon city and is located at just 425 meters from the site in dispute. Is ready for rehabilitation and the applicant petitioner shall be allotted
Shops, my lord, which were allotted to similarly situated.
shops markets.
No, on ownership basis is what they've said, on ownership basis to the eligible petitioners.
On ownership basis
Yes, yes.
to the eligible petitioners.
Yes, but let it not be by lottery, my lords, because we have different sizes, so.
Ownership basis to the eligible petitioners on the same analogy as have been allotted to the other
Similarly situated land.
landowners.
Well, I don't know what those principles are that they followed for the others. I'm sorry, I just want to say this because since we are disposing it off, your lordship may just indicate that it will be commensurate to what we have.
Because they have got the compensation as well.
The others have not taken this issue, my lords. We are the only ones. We've come here repeatedly.
They have paid the compensation.
Cause of action to them, because they will say, we were never. No, because if your lordships are modifying the order, just 1 minute. If your lordships are modifying the order said that we will not be entitled to seek enhancement and compensation. Try to see that if the possibly whatever the nearest size is available, that may be given, otherwise.
Lord, your lordship.
We were owners of the property.
We will be opening Pandora's box.
No, your lordship can make it clear.
Only on a pro rata basis.
Yes.
Like someone is
I do
having
not-
400 square meters at the site, Samstha site, he may not have lesser than who has 200.
Yes, this question never arose, therefore I am unable to respond.
Right, that is
Because
again.
this is something not in the High Court, not in SLP, not even in the MA. The difficulty is, if suppose similarly situated person is given, say, 200 meters, then he will be given 200 meters.
That's why.
In the moment we deviate.
Only those who are
others
before this
also
court.
Similar person, similar, at par with similarly placed person.
Yes.
Similarly placed are already gone. There's no similarly placed now. There's only this finite number of 20.
Order is quite a 20 minutes.
We cannot discriminate, Mr. Gopal, please appreciate. If the other landowners have been allotted a particular.
Yes.
And they have been given compensation as well.
There are no other landowners.
They have been given enhanced compensation.
They have taken compensation and gone. The rest.
First you get the shop. Then if you feel there is an arbitrary allocation, there is a second round.
So I have one suggestion. I have one suggestion.
Cost is concerned.
I have one
Now,
suggestion.
there is a
only.
committee, let
Your
that
Lordship,
committee headed by collector will determine the cost in view of rule 9, my lord, of the 1983 disposal rules, my lord. So that
Not entertaining any claim of the municipal council that between you and the state government.
Your Lordships have, if you're modifying that earlier order,
clarity on your property.
if you're modifying the earlier order, my lord,
No,
the
no.
earlier order
but
permits.
my submissions be recorded. My
We have
officer
paid
will land it.
consideration to them.
Oh, they are.
They get
Yes,
their,
my lord.
they get their
We
money.
means the Sanstan.
We pay.
Oh, sir.
Yes,
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 yes.
yes.
For
I
them,
don't know why are they coming.
for them
There
and
is
for
something
him,
else, my lord.
for both.
Now, because the Sansthan has paid them, your Lordships may note that in that para which you're seeking to modify at para 14, your Lordships have noticed, and if the authorities decide to adjust them under that project, the petitioners shall not be entitled to seek further enhancement and compensation. Now, the other similarly circumstances were encroachers. As far as owners are concerned, we are owners of the properties. Some of us have 110, some have 40, some have 60. Now, if a 110 and a 40 both get 10 square meters, surely if you modify this, I can't even get my enhanced compensation. All I'm saying is either leave that allowance available to me or give me commensurate. I don't think that's unreasonable. I don't think that's unreasonable because I have an order today.
It's a separate cause of action.
No, it's part of this order. You're modifying this order. The court's order is in my favor.
Millets,
Now, if this is being modified at their instance, all I'm saying is either commensurate
Millets,
or
the-
leave this alone as it is.
the owners were paid enhanced compensation. The encroachers were not paid.
Yes, we are owners.
That way they've already been compensated.
We are not
They can't have
encroachers.
more and
I'm sorry.
Enhanced compensation.
They have already
No.
enhanced compensation.
No, we are not.
And they cannot
have not
have over
taken.
and above.
25% above.
And rehabilitation
Mr.
is
Naidu,
only
this doesn't
humanitarian.
concern your client, it concerns
Millets,
Mr. Mehta and me.
Humanitarian gesture that they were accomplishing.
Humanitarian, taking my land and my livelihood.
We are not taking
You are getting your compensation and you got it.
Allotment.
Them.
Mr. Gopal, we don't want any. Dehots pleadings, the factual matrix diverge before us.
Correct.
That is why on principle, we are saying go for option 2 as proposed by the state. And if you go as per
So,
the.
if you've seen option 3, my lords, option 3. So, all I'm asking is a combination of 2 and 3 because I don't know what the extent is that they're giving me. I don't want to push it off unnecessarily and burden your lordships again on another day.
Shop and compensation both.
Yes.
What will happen? Suppose you go at the site.
Yes.
You find the size is okay, reasonable for you.
Yes.
You will take. No,
End of the matter. End of the matter.
if you find that size is not at all.
Yes.
Your option is already there in the judgment. You are entitled to compensation.
Yes, but if your lordship modify it, then that's gone. That's my problem.
No. If
Oh,
we
you're
are
not, if your lordship is not modifying, that's no problem.
However, if we can mention, however, the applicant petitioners do not opt for the shop.
Yes.
Being offered to them.
They can
They
revert
will
to the
shall
third
be at
option.
liberty to avail their remedy for enhancement of compensation in accordance with.
I think that's fine.
In accordance with.
I don't think we can. That's fine. That's
That not viable, go for enhanced compensation.
Grateful.
But MA is disposed of.
Disposed.
So there was a status quo that prevented.
No disposed.
Right.
Grateful.
Just, can we have 2 weeks time?
2 weeks time to
2 weeks
vacate.
time to vacate.
2 weeks.
Because once they allot, he said tomorrow, then give me just 2 weeks. We've been there for years, so.
2 weeks time to shift it in with them.
Grateful.
Yes.
Great.
I'm grateful. That 2 weeks, I'm presuming applies to Mr. Mehta's client also because I can't vacate and then not have anything in my hand. If it's being done tomorrow, day after, then we're 2 weeks.
No, they have to vacate and get possession. It's not that.
You will give it to me, na?
Obviously.
Why, when they
obviously.
give it to me, I'll.
This 2 weeks is not for filing some other litigation and seeking.
No, it is 2 weeks for them to give it to me. I'm grateful.
Item 72.
These are 72, my lord.
Some other non-miscellaneous case.
My lord, it's just
There is
a
an
request for extension of,
for-
joint request.
My
It's a
lord-
joint request for extension of time of the mandate of the mediator, that's all.
Mediator granted case.
Mediator was appointed by your lordship, so we are seeking extension till 1st August, my lord.
Some more time is left. Item 73.
This mediation, my lord, was referred before the mediation center. It's been-
Successful, Lordship. It's been settled.
Settlement has taken.
IA number 84725, my lords, parties have filed joint application seeking, my lords, under Article 142, dissolution.
In terms of the settlement, I have to hand over the DD.
Or let's say the pursuant to the. Yes. Yes. So the matter was referred to the Supreme Court Mediation Center on the request of the parties on 17th September 2025. The parties have under the duties of the mediation center resolved their dispute amicably and a settlement agreement dated
13th February.
13th February 2026 duly signed by them, their advocates, and the learned mediator has been placed on record. As per the settlement, the respondent husband has paid a sum of which
5 lakhs DD, Your Lordship, I have to hand.
5 lakh by way of demand draft number so and so, so and so. So there's a nice to get after number so and so, so and so. As per clause 5 in bracket capital A of the settlement. The what is her name? Shubham?
No, my lords, Kajal Ishwar
Kajal is
Kedar.
by-
The draft has been handed over to the respondent Kajal Ishwar Gedam, who is present in court. The parties have further agreed to dissolve the marriage by way of mutual consent. Since they are living separately since
9th of July 20.
since 9th July 2022, that is more than 3 years, and it seems to be a case of irretrievably broken marriage, we deem it appropriate to invoke our powers in Article 142 of the Indian Constitution and dissolve the marriage of the parties by way of a decree of divorce by mutual consent, ordered accordingly. Next paragraph. As agreed to between the parties, the following cases filed by them against each other are hereby closed. First, MT case number 2284 of 2024, filed under section 125 CRPC, pending before the learned principal judge, family court, North West Rohini Courts, Delhi, is disposed of as having become infructuous.
Yes.
Right? Next, Silky case number 8262 of 2024, having CNR number so and so, we page pending before the Metropolitan Magistrate, relief denounced under section 12 to 13 to 23 DVR, is also hereby disposed of as being not pressed for. Then 3 is FIR number 0675 of 2024, registered at police station Sultanpur, Delhi, under section 498A 406 34 IPC, and all the proceedings arising therefrom are hereby quashed. Then say application bearing criminal MC number 7831/2024, filed by the petitioner husband under section 582 of BNSS for quashing of the above stated FIR, and which is pending before the High Court of Delhi, is also disposed of as having become infructuous. Any other thing?
No, Your Lordship, on this.
This was the parties shall say the settlement agreement is made part of this order. The party shall abide by each and every term and condition of the code.
Great.
Okay. Please check करना।
528, your lordship.
528 हमें तो याद होगा नहीं बोला था।
Grateful.
Item 74.
0.6 mlos. For I appear 74.6 mlos. For R3, 4 and 5. I seek some time to find Wakalatnama and
Lords, in the other transfer petitions, my lords, I am appearing for the respondents, my lords. The other respondents, my lords, the 4 respondents.
I'm for the petitioner, my lords.
Lords, we are not opposing the request for the transfer.
I think mutually,
Please, my lords.
the parties are very gracefully and mutually resolved that the cases, subject matter of TP number so and so, so and so, so and so, may be transferred to the from civil court, be transferred to the court of competent jurisdiction at Patiala House, Delhi. So all the above stated cases are accordingly on consent order to be transferred to the courts of competent jurisdiction at Patiala House, Delhi.
My lords, I just
Learned Principal District Judge at Patiala House is will entrust the cases to the respective courts.
Please, my lords.
Any other thing?
one issue, my lords, for the petition. My lords, since Delhi High Court has an original side jurisdiction, I suspect that the pecuniary jurisdiction will come into the High Court. So it should simply be that if I move an application for the appropriate financial pecuniary jurisdiction, then it will have to go to that.
You are right. That need to be clarified. It has been pointed out, and rightly so, that in some of the transfer cases, the issue of pecuniary jurisdiction may arise. It is clarified that once the parties move an application, irrespective of the issue, irrespective of the prescribed pecuniary jurisdiction, we direct in exercise of our power under Article 142 of the Constitution that the courts in Patiala House shall have jurisdiction to entertain and decide the cases on merit.
My lords, that means that the High Court will not step in, is it?
That's it. That's it.
Very well, my lords.
Some of the matter will go to High Court. Some of the matter will go
That's
to
what.
To avoid
That's
that,
what, my lords.
To avoid that,
My lords,
Patiala Court will entertain. Patiala House Court will entertain.
very well, my lords.
I think that
Yes, my lords.
practical way.
Yes, my lords.
My lords, may I be allowed to give my appearance in physical, my lords? My appearance in physical, my lords. My Wakalta is not on record.
Appearances may be.
Capital Area Local Bank.
File the Wakalta.
Great.
Let's not keep these matters pending for a long time. इतने matters लगा रखे हैं, दो से कई दिन में लगा ये क्या 7
Lord, 75 has become infectious, my lord. It has become infectious.
Millards, I seek 2 weeks time to file a fresh Wakalatnama on behalf of the petition.
File the Wakalta.
Lord, it's a 24 election already. That period is also over, my lord.
I'll come on.
Lordship may kindly see High Court judge was appointed for conducting election. They contested last election.
Take up because let him file Wakalta 2024 met list on so and so day.
Much older.
Deeply.
Item 76.
Please, my lords, I appear for the state, my lords. As per the last order, my lords, the report is awaited.
On joint request of the parties, closed after 8 weeks. 77 to all matters are now adjourned to different date.
That was 77.
Even in the counter, they are not denying the arbitration agreement. Your lordship may recall that, my lord. Last week it was there, lordship deliberated. Yes, my lord. Some retired High Court judge, somebody.
Who is opposing?
Your Lordship, in item 79, this item 79, my case is that the invocation itself is defective.
Take all the objections before the arbitrator.
Yes. Your Lordship, admittedly, as per the invocation, there has been a settlement as per the invocation, as per the terms of the invocation.
It's an issue that has to be determined by the arbitrator only.
Yes, my lord.
How do we opine on it?
Ex facie, as per the invocation notice itself. If I can demonstrate.
Suppose we tomorrow reject this argument and then send the matter to arbitrator, will we be able to decide?
I bow down to that.
Please appreciate.
I bow down.
Your
Lordship, there will need to be 12 separate.
Item 79.
Your Lordship, in item 79, there will need to be 12 separate references. There are 12 separate section 11 petitions.
Composite agreement says the same arbitral tribunal will decide all of them because they're all
Your
party
Lordship,
to the same agreement.
This is a matter then will have to be heard.
Common, we can give to one arbitrator.
Yes.
Common sole arbitrator, I have no difficulty.
Yes.
But 12 separate references to the same common sole arbitrator.
12 references.
Yes.
To the sole arbitrator.
Very well.
1, 2, these proceedings are to be conducted where?
Delhi.
Delhi. The agreed venue is Delhi. my lord.
All right.
I'm retired.
May I mention item 80, my lord?
I think the order.
Oh.
Your Lordships may say that all contentions are left open because we had taken
All
that
objection,
objection.
of course.
Very well. Some retired.
There is a letter, veterans. So anyone in 80?
My lord, I am in 80, my lord. These are two section 11 petitions, my lord.
Your Lords, in this matter, Your Lords, we will have to refute it because, Your Lords, this arbitration clause itself is invalid, Your Lords. So may keep it on any date and we'll argue.
By invalid, we will determine a valid or invalid.
Your Lords, the arbitration clause is vague and the invocation is also wrong, Your Lords.
So you deposit first of all argue post in the court. When you want to raise this kind of objection.
Your Lords may keep it on any date. We'll argue and get the matter, Your Lords.
Otherwise, there's an arbitration agreement, my lord. It will be appointed by
Are
court.
raising an objection that the arbitration clause is invalid, or subject to the cost to be imposed by this court. Post this matter on so and so date for determination.
Not for the convenience of the honorable court, for the order, I prepared a sequence of events and the judge, and the composite agreement where the agreement is mentioned. And it also agreed, it's at same tribunal, it's a consolidation clause also. Therefore, I impaired.
My lord, in item 80, could it be
Item
a fixed
79,
date,
madam.
My lord, in item 80, could it be a fixed date, my lord? Any date?
Fixed date or no, every matter we give a fixed date.
Your
Lords. One in item 81.
Milord, 81, Milord, is also, Milord, is about appointment of arbitration, Milord. Service is now complete by the affidavit.
I am for the respondent, my lord. My lord, the disputed amount is very short. It's 3 crores 36 lakhs.
We can request some young advocate. We can.
Yes, your lordship.
Yes.
The place is where?
Delhi,
Delhi, my lord.
Delhi.
Delhi.
Delhi, my lord. 3 crore 36 lakhs, my lord, is the share transaction. This arises from a share purchase agreement.
Young advocate.
Please, my lord. Your lordship may.
As your Lordship, please.
Okay.
Please, my lord.
One request, my lord.
Your Lordship, if I may mention, there are certain matters of the same issue.
Throughout the day.
Your Lordship, it's the same issue, but they have not been listed. Yes, yes.
She says so.
Yes. It's in the case of Aristophanes. So.
Now, Mr. Mistry and Mr.
Most cases notice of.
I'll give the details. Much obliged.
We kept on applying mind. The ultimate solution that we'll have to find out by us is that no prejudice should be caused to both sides.
That's right.
One. Two, there is undoubtedly a subsequent event, namely a new enactment coming force retrospectively. They say it's a clarificatory amendment applying retrospectively. You can have hundreds of objections against that.
True.
Law provide you certain grounds to challenge that. The orders, High Court judgments are in your favor. That's why the revenue is here. There is no, by virtue of the High Court judgments in your favor, there is automatically a stay in your favor.
Correct.
Right?
Correct.
Because initially the High Courts might have granted, may not have granted. We are not sure because it depends on different.
It's the notices. All notices.
The reassessments have been quashed.
Quashed. All notices are gone.
No. During the pendency of the writ petitions, was there any stay?
There was.
There was.
Not long.
In some of the High Court, there might be stay there.
Yes.
Any other, it might not be. What we are proposing, we are using the word proposing is out of humility and otherwise this is the. We will take notice of the subsequent event that this is how the amendment has taken place. We will then say that is there any impact of this amendment in the proceedings initiated by you people in the High Court or not is an issue that requires determination. Three, we are not inclined to express that opinion because it will prejudice the party.
Yes.
Very well.
Very well.
Four,
Yes.
Only on this technical ground, only on this technical ground of subsequent event and subsequent legislation,
Right.
we will set aside the High Court judgments, remand the cases to the High Court.
Right.
Interim stay will continue in your favor.
Very well.
We will request the High Court, we will allow you to amend the writ petitions to challenge the amendment if so required.
I understand.
And we will request the High Court to decide the writ petitions by 31st July 2020.
Lordship.
Very well. Very well. Very well.
Right?
All contentions open.
No, if I know what this is, second humility.
One small prayer, if your lordship permit. The High Courts in the impugned judgments have said we have not gone into the other issues raised in the writ petition.
Right.
So
All rights and contention left.
Go into those issues.
That's right.
Yes.
So-
There is another proposal, but that all depends upon you. If you will say we will do, otherwise we will not do. If you want to avoid that different High Court taking different.
Correct.
If you want to put full force at one place,
Please.
we can send these cases to Delhi High Court or to all Bombay High Court.
Different. No, we'll not multiply. To that extent, can I say this? Lord, what happened? I'll explain one narrative.
Different High Court situation.
Yes, sir.
Different High Court. Please.
Can I just say this, my lord is absolutely.
Let him finish, my lord, then after that, right? He will like to speak first, let him.
All contentions, my lord, all
Correct.
contentions as my learned friend
Yes,
said,
yes.
Sure.
have to be urged.
Of course, one of the Arjun, it is expressly clarified that various other contentions are also sought to be raised on behalf of the parties. We, however, do not take notice thereof for the reason that the matters are being remanded to the High Courts on a technical ground. Therefore, we leave it open to the parties to raise their all other contentions
also before the High Courts, and the same shall be considered in accordance with law.
Very obliged.
Two suggestions, my lord, if you
Those contentions which were available to us on the first notice.
That's right.
On the first notice.
Such contentions will include, will also include the pleas which could be taken by the SSEs at the threshold.
Right.
At the threshold when the petitions were.
two submissions.
Right. And also, my lords, one other thing, all contentions relating to the effect and impact of the retrospective amendment.
Naturally.
That may also be expressly mentioned, not just other contentions, my lords, because, yes.
In light of the.
No.
Namely, the amendment of the Income Tax Act so-and-so, section so-and-so, and introduction of new provision, that is section
47A.
147A. Section 150.
150.
Yes, very
Of
important.
the Amendment Act, we grant liberty to the SSC in bracket writ petition before the High Courts to amend their writ petitions within 4 weeks, and lay challenge to the amended provisions, if so advised. It's your review. Your
Two
Lords,
submissions.
Wherever the stay will be, that continues.
the interim order.
Proceeding will stay because judgments are in favor.
Yeah. Right.
During the pendency of the petition before the High Court, the matter, proceeding will actually remain stayed.
There shall be interim stay against the assessment proceedings.
Yes.
Lords, one small clarification.
The High Courts are requested to decide the matters preferably by 31st July 2026. Land Council for the parties undertake to extend full cooperation to the High Courts in this regard.
The Lordship, looking to the vacation, maybe 31st July, maybe 2 days, maybe 30 September, that will be good.
Can I
June,
make a submission?
across India, June will be vacation.
I need 1 minute.
Small point, sorry.
30th September will be good. Yeah.
Just one small. Yes, sorry.
Two submissions in your lordship's court. My lord, I will cite a precedent for that. My lord, we had a similar problem in indirect tax. In indirect taxes and customs law some time back, which stayed in the courts for 18 long years in different forums as to who would constitute the proper officer for issuing a notice. So, my lord, 2-3 rounds, one judgment came, and we made an amendment retrospectively, as we did now, because 18 years of litigation was getting stuck. Lord, this court permitted a challenge directly under Article 32 because matters were live and pending here. So matters were challenged, constitutional validity was challenged of the proposed amendment. Both were together heard and disposed of finally by this court. And my lord, it gave a finality for 18 years of bliss. So, same problem, two options, we place it in your lordship's court. But this is a legal issue. It's not a factual issue. The other issues in the show cause notice are factual, but what happens normally, there will be a show cause notice will have 10 issues. You will go and get a stay saying "Jao fao." Rest of the issue, High Court will not apply in mind, because rest of them will be maybe even relegated to alternative remedy. So those are all individual issues we will not get into. The legal issues of competence of this legislation is a pure challenge to the pure question of law. Pure question of law. Wherever it is heard, it's got a question of law. Should we multiply it within 3 months, 10 different high courts? Or one high court is something which your lordship may kindly consider. No. Multiplication.
Ideally, it should go before one high court.
Yes.
The problem is that we cannot suppose.
Your lordship has been doing that.
Not 2,000 cases, please. You can't burden
But
the one high court with so many cases.
Lord, may I put it this way?
And there are many issues because the other issues are there, petitioners are there.
Lord, I have been waiting. Can my friends wait for 5 minutes? Can I be?
The AST tax bench is already an expert bench. And if you put all 2,000 cases in one bench, it is difficult.
Lord, may I put it this way? I understand.
3 or 4
But when the legal issue, Lord, may I put it this way? Lord, I will tell you, we'll put our constraints and we'll ultimately your lordship will decide. Lord, this is, as we said on the first day, this is not some new list which happened 1 month back or 2 months back. It is 5 years old already. And 2 times we have come and succeeded. This is the 3rd round. First time we succeeded in Ashish Agarwal. Second time we succeeded in Rajiv Bansal. Now, my lord, we have now, I can make this statement.
No.
I have a confirmed from the L&R. We made an approximate calculation. So far in these notices for 5 years, 16.5 lakh crore income remains unassessed. Remains unassessed. One minute. Why don't you allow us to speak? 10 people start speaking. So,
You're
1 minute.
You're telling only about the cases which are pending in the Supreme Court.
No, I'm not saying pending in the Supreme Court.
Cases pending across the High Court.
I'm saying, my lord,
They are
I'm saying after fact, my lord, I'm not saying 2,000 cases alone. This, whatever is pending, my lord, my lord, we initially issued some 90,000 notices. It's now coming back to some 37,000 notices. The ballpark income unassessed is this magnitude. All that now speed and time is essence. Let me allowed to present what I wanted to present. I think a revenue council is responsible to put what.
Understand? We appreciate your concern.
Yes. So time factor is one, and it's a legal issue. I can understand if it's a factual issue. Well, as of now, 6 to 7 high courts, three in our favor, 4 in their favor, have been giving opinions. So will your lordships consider either two options as we did in canon, whether we can come directly here and argue? All right. If not, your lordship wants a high court to appreciate it, then come. Please consolidate it in whatever high court. We don't want to choose anything.
Gentlemen, we would have accepted your first contention of entertaining 32 petitions, provided that the only issue was regarding validity, constitution.
Only issue.
No.
Unfortunately, there are some now, as you have seen right now. They are saying some grounds were available to us, which we did not take at that time.
No, may I put it this way? Well, I'll answer it this way. Well, I'll assist the court. It may take minutes time. My lord, the notices, whether, my lord, it is a show cause notice comprising of various issues. This is the same case even in canon. Whether the officer who issued is a competent officer or not is the legal question.
No.
Whichever way it goes. Once competence is restored, then it will go back to the officers to assess everything. Your lordship will not conduct, whether it's a high court or a Supreme Court, nobody is going to conduct assessment.
See, somehow there are some factual issues, whether those are of significant value, whether those have any impact on merits of the case or not.
I say with great 1 minute. It's very important. I try to persuade and leave it to your lordships. My lord, let me make it very clear. The cause for this challenge for last 5 years in 3 rounds is now the 3rd round. First 2 rounds they did not raise it. They have now raised it in the 3rd round. Is whether every notice, whatever is pending, 30, 37,000, whatever number, whether the jurisdictional officer issue or faceless officer issue, which we have now brought an amendment. So they are free to challenge. Nobody can prevent them from challenge. So the question to be resolved in all this is 147 years read with 150 years. Whether the notices already issued by job is constitutionally valid in the light of the amendment. That's the only issue your lordship. Whether High Court decides it or your lordship will decide only that. If it is held to be invalid, all notices will go. If it is valid, it is all in the show cause stage. Every assessment order has to be passed only by the officer on whatever issues he has to.
No.
Yes.
Call be taken by the High Court.
Go before different high courts. Let the wisdom come from different high courts.
Where different High Courts have taken this.
Stick to one high court.
It made our difficulty, and personally speaking, as the Chief Justice here, I know the difficulty that even if I have to constitute a bench, my sister has 70, 80 cases, first of all, miscellaneous urgent matter, then these matters, so thing will happen. Our bench, we have also practical difficulty.
Right.
Therefore, we are requesting the High Court in a time-bound manner. By 31st July, we are fixing the date. Let's see what the view they will take.
Your lordships have given us liberty to challenge the amendment. Challenge the validity of the amendment. Very well. Now, independently of our challenge to the validity of the amendment, we have substantial submissions with regard to the interpretation and impact. So that may be put in. Otherwise, we may be restricted before the High Court. Just a constitutional challenge to the amendment.
He said that if there are other grounds, we know that the SSCs will create hundreds of other grounds.
No.
Even amendment.
There are grounds which are apparent on the face of the amendment.
Amendment is not happening.
But that...
that may be clarified, because we don't want to be tied down to only a constitutional challenge.
All content.
All issues.
Yeah.
Rather, 3 weeks amendment, amended resolution within 3 weeks because...
Very well.
Your Lordship, a date maybe
Only one
31st
small
July,
issue may I
30 September.
request
Maybe.
notice.
No.
Not one small issue pertaining to assessment year of 2015-16.
Yes.
So that will have to be separated.
No,
Yes.
my lord, there's a confusion there, so please keep it separately for two reasons. My lord, what we have considered specifically, I said to this court, in Rajiv Agarwal, the second round, we have considered for the window period of 1st April 2021 to 36 June, wherever we have invoked 2015-16 under the normal time, including TOLA period, is barred by limitation, a concession given by us. So whatever is governed by Rajiv Bansal, there is no difficulty. We are working in the list. But now what the list is saying is, several has come. Any 2015-16, they want a blanket saying that. So there are cases where somebody has invoked regular 6 years, extended period. Those cases are also.
Those are also remanded.
No, not.
No, can't be.
Unless we. So 2015-16 will come back. Which has to go?
No, last order में था ना.
Your Lordship will sit after 2 weeks.
Your Lordship has already 4th of May.
Yeah, 6th April 2016 is the order passed.
67. Yeah. Another 25 matters have come today. We will verify all. Every case we are now verifying it. Because we need to be clear which is covered.
Keep them separate.
Very well.
Because there are other matters which are not concerning with this jurisdictional issue. The issue which has been decided by the High Court is only on the question of limitation.
You can.
On 13-14 minutes, the issue that has been decided was only on limitation and not on jurisdiction.
We will hear you. Thank you very much.
Those matters cannot go back.
Give you a list.
Very good.
Yes. Hope we don't come for like